Mr. Bora.
May it please your lordship. Lordship, item number 38, my lord. Today we are going to file affidavit in reply, my lord. And I want to consent for next week.
For that,
Next week, my lord. Any day, my lord. Already we are going to file, my lord. They are coming.
on the prayer of Mr. N. Bora, who submits above N. Bora, lists this matter again on 29/1/2024.
My lord. My lord. My lord.
In the meantime, the parties may complete their pleadings.
Much.
See to that it comes on record.
Today I already going to file.
May I please, Lordship, I beg to mention item 31 also. In this case, we have affidavit.
On the prayer made on behalf of Mr. P.D. Nair, Learned Council is hearing, Learned Standing Council quoting is this matter again on 13/1, 13/2/2024.
13-2.
13.
Obliged.
Yes,
Mr.
Mr.
Lordship, Lordship, item number 41, Lordship. I'm praying adjournment on behalf of MSK Devi, Lordship. She is out of station for our treatment. Lord. So this matter may adjourn. Lordship.
On a prayer made on behalf of Mrs. A. Devi, Ms. MSK Devi. He is presently under medical field. List this matters again. When do you want it?
After 4 weeks.
4 weeks. List this matter again after 4 weeks on a date to be fixed by the ministry.
Applies. Lordship.
Yes, Mr. Khan.
But we are praying for listing of 3 repetitions on Monday.
When?
On Monday.
Monday, there might be a slight problem. This vote might be a bit late.
Tuesday.
Let it be on Wednesday.
But
On Wednesday. Goodbye.
much of
May I please, Lordship? Lordship, I also beg for listing of a matter, Lordship. On Wednesday, Lordship?
Next Wednesday?
Yes.
Fine, no problem.
Obliged, Lordship.
Any listing matters? You can
May
give it.
feature Lordship. Lordship, item number 4. My lord, the senior is out of station, my lord. My lord, kindly adjourn the matter after.
You be here for some
Yes,
time.
my lord.
It's a 12 matter. We are not adjourning it like. Just be here for some time.
Okay, my lord.
Let the matter be.
Obliged.
My pleasure, Lordship. I beg to mention item number 37, Lordship. Matter may be kindly adjourned for the day, Lordship. We have taken the consent from other side.
You are 40?
I am for respondent number 5, Lordship.
Your appointment as president is under question here. Sorry. You are appearing on behalf of whom?
I am appearing on behalf of respondent number 5, Lordship.
You are there in the matter.
MS Mandal, yes, Lordship.
You are MS Mandal.
Yes, Lordship.
Be here. Let's see what it is. Be here for some time. 38, it will reach immediately. Don't worry. Be here. Be here. Let's see if there is something. There is something we will absorb.
Lordship, item number 19 Lordship has become infrastructure. 19 Lordship. I am for the petitioner.
You are for Mr.
And
Yes,
Sorry.
N. Hawk.
Lordship.
You are N. Hawk.
Lordship.
Mr. N. Hawk, Learned Council for the petition. Commits. During the pendency of the matter, the petitioner has got a relief.
Yes,
Petitioner has got a relief.
Lordship.
The petitioner has been granted her relief according matter has since come. The matter accordingly stands as infractions.
Top of the list matter, item 1 and 2.
Maybe Lordship, my lord, in this case, actually, the both the petitions are covered by a decision of the Honorable Court, my lord.
Mr. Das.
My lord.
The decision that you are relying on, fine.
My lord.
It is there. But while I was going through this matter, another thing came to my notice.
Well,
We can come to page 39.
Thirty, my lord.
39 is an
39.
amalgamated list. And your name figures at 514
My lord.
and the second petitioner 515.
Well,
And the private respondent number 4 is at 631.
my lord.
You have made statements that this amalgamated list is for all the ministerial staff in the
Right.
establishment under the Commission of Tax.
My lord.
Commission of Tax. They have not denied that.
My lord.
So if this be so, and your appointment, your posting orders not having referred to that 54 circular.
Well,
So if you are all in the same cadre, at least at that point of time,
well,
this is a gradation, amalgamated gradation list of 2008, February.
well,
And that check gate was closed in the month of July 2000. If that be so, how can your seniority be depressed? Your seniority cannot be depressed.
well,
Your seniority, you will carry your seniority. And
Hello,
if that be so,
only I am telling, my lord, I am
if that
telling
be
only
so,
to-
then the promotion of respondent number 4 ahead of you was not correct. But respondent number 4 was promoted in 2008
my lord.
or something. And and I get more. In fact, I was possibly. So in that view of the matter, without disturbing her promotion,
Well,
at least Deepa Borkotogi must also be directed. So this is just tentative, subject to what there.
Right.
Must also be directed to be promoted from that day and concerned.
Right.
But Deepa Borkotogi was transferred to the office of the Deputy Commissioner of Taxes,
Right.
DCT. So, okay, the respondent number 4 is also in the DCT. Now, what is the status of the other petitioner who was transferred to the post of establishment of ACT? Is ACT and DCT same office?
whichever.
Same.
Same,
Means you mean to say that DCT Tezpur and ACT Tezpur, same ministerial staff?
Well.
Sure.
no, before the actually, my this, just I am showing your lordship attention to pay. Maybe. Annexure part 15, my lord, page 47, my lord,
47.
47.
Hmm.
If the regulations made by the Commission of Taxes, my lord, pursuant to my representation. You should.
Idea. People like. The portion is more tabulation.
Here's the last matter. I would therefore request the government to kindly favor this office with a
No, that is my
regarding.
last line, in their
Yep.
respective present offices.
Hello.
Now, is these two offices same or different?
Well,
If it is different, then the other petitioner, Soikia, may not have a claim over
well,
her.
Well.
Deepa Borkotogi will have.
Well.
We'll just ask Mr. Chaudhary, then come back to you.
Well.
Yes, Mr. Chaudhary. Madam. Just have a clarification.
Yeah, okay.
You had in 2008 prepared a amalgamated edition list. Page 39.
Yes, ma'am.
And you have not said in your replies that this is not applicable. So if there is an amalgamated seriatim list of all, then without giving them notice that we are applying the OM of 54 in their case, how can you depress their seniority? What do you have to say?
Lordship, only one handicap is there for me today. Lordship, I have misplaced the file. I have to reconstruct it. Lordship, I will answer your query, Lordship. I have just taken the second copy.
Can we have it? Because this is 2012, but I don't want to.
That's
disturb it.
Lordship, let the petitioner may complete his part or Lordship, whatever.
I think
Lordship,
there is
on
nothing
Monday
more
or
to be done from the petitioner's side. This is the issue.
Lordship on Monday, Lordship. I can address this or Tuesday, if Lordship.
I'll hear, madam.
Monday, 27.
Yes, madam. What do you have to say?
My learned friend is paying for time.
No, fine. Let him pray for time. What is your stand? Because madam, you
Case
see,
is
come to
regarding-
page 39. Come to page 39. 39.
39, page 39.
39.
Yes.
This is an amalgamated gradation list.
Oh,
It's an amalgamated gradation list.
39.
If you come to page 40,
Okay,
40,
40, yes,
514, 515
yes.
is the two petitioners in these two cases, right?
Serial number 514,
514.
each petitioner's name appears.
Yes. And your name appears in page 41,
Yes,
631. Right? Now, if this is the amalgamated seniority list, that means you all are in one category. Then, once that Patlimari checkpost was closed, they were transferred. There is nothing there saying that their such transfer or redeployment or posting will be under the 54 circular. So, in view of this, they will naturally be seniority. What do you have to say on that?
my lord, first of all, abolition of post is the discretion of the government. That is, their decisions are also there.
Hmm.
But secondly, my lord, they were appointed on humanitarian ground. And there is an office member.
No, madam, that unfortunately is the stand of the government when they were disposing of the representation. Before that, this stand was never there. And the stand in 2008 is this page 39, amalgamated, which you find a forwarding at page
39.
38. Even the
Final
order
amalgamated
by which
decision
they were
is-
transferred, which you will find at page
My lord,
23 of the affidavit.
hmm,
Nothing is there.
yes,
Right?
nothing is there, of course, but the representation she made, that was rejected in the year
I
2011.
got it. In that rejection, many things have been said,
And
but that
referring
is
to-
not supported by
referring
the
to-
orders passed at that point of time. This representation was disposed of sometime in 2011.
2008 perhaps,
11.
yes, and it was rejected.
You can just come to one more page, madam, 49, page 49.
Hmm. Oh, it was referring to office memorandum of
That office
1954.
memorandum reference came only in 2011. At page 49, if you can just have that page 49, this petition. Page 49, 49,
Hmm.
Next, 17.
49 you have,
Please.
page 49, 49.
Yes,
We can just read
Yes, I have
this.
seen
It's by
that-
the Commissioner of
yes.
Taxes. With reference to so-and-so have the honor to state so-and-so have rendered their services during the
Yes.
erstwhile so-and-so. And as they were transferred and posted in the office of Deputy Commissioner so-and-so. So here in 2009,
yes,
their such deployment is treated by the Commissioner of Taxes as transfer. If it is transfer,
yes,
they
there,
carry their seniority. Anyway, we'll give Mr. Chaudhary a chance. We'll have it on Tuesday, Mr. Das. If there is anything more to be added, Mr. Das, if there is anything more to be added, just highlight it. Otherwise, I think this is the issue. Mr. Chaudhary, I'm giving you time, no problem. You justify that representation disposal order. That is that page.
In that letter, my lord, your lordship has referred, my lord, page 49, my lord.
Hmm.
That is especially it was mentioned, my lord.
Transfer and posting.
Where for determination of interstate seniority at their present places of posting, according to our view. These are the due.
Mr. Chaudhary, you get hold the records. If the records show that while in 2008, when they were being deployed, you had applied the 54 circular, it would be a different ballgame altogether. If you have not done it, subsequently, whether you can go back to that. That's the only thing. Get your hold of your records. We'll have it on Tuesday. Mr. B. Chaudhary, Learned Counsel, appearing for the Finance Department. Finance Taxation Department. Taxation Department prays that he be granted a short adjournment as the concerned file has been misplaced. Also, on the prayer, so may list this matter again on 23/1/2024 as a part-head item. Mr. Chaudhary, on the next day, shall, by producing records, justify the stand taken by the respondent authorities in the speaking order dated 16/7/2011, page 54 to the petition. Heard, Mr. NC Das. बाकी की नहीं लिखी लो. We'll have it on Tuesday. Tuesday. You also examine that matter. Whether by having it as a single amalgamated establishment and there is nothing being there referring to 54 circular, whether their seniority can be deposed. This is the issue.
Item number 3.
Other than adjournment, anything.
Well, actually, what happened? Well, I just got the second.
Before I argue, my lord,
Few minutes back.
kindly see to what extent High Court has gone. Well, we are for a service matter where I lost my livelihood. And today probably they are asking for time again.
No, well,
Mr.
what
Das,
happened, my lord?
Mr. Das, we have gone through the brief. She may have committed the gravest of error. She may have been working in Lonavala during that period. Nothing like it. But do you know what mistake you have done in passing the order? If you can come to the impugned order. Page 103.
Yes, my lord.
You see the second paragraph. Having considered the reply to the show cause submitted by her and the report of the inquiry officer, so and so, then so and so, inflict the penalty of dismissal from service. Subject to what you satisfying me, there is no admission on the part of the petitioner. It's a clarification. And how could you have taken this inquiry report for imposing a penalty on her without having it proved in an inquiry? If it was the first part, maybe I would have been with you. But why this inquiry report was taken on record? So we'll proceed in the matter. Mr. Butcha, you can start.
May I say something, my lord? My lord, what happened, my lord? We missed this item, my lord, because our name was not shown, my lord. If matter may be fixed tomorrow also, my lord.
We can't trouble Mr. Butcha ji
Yes, my
like
lord,
that.
my lord.
We can't trouble him.
No, not only that, my lord.
And this lady is waiting for a long time.
If that is so, it is minimum courtesy to inform me.
That's
that
true.
is-
Why did not you inform? They missed the matter, maybe.
I don't know, my lord, nobody insists on it. Earlier, my lord, Even a junior appears to inform me that I'm going to seek an adjournment. I don't know
Mr.
what has happened.
Vatsaji,
Let me-
cutting the long story short,
Mayor, let me formulate the point.
yes, just one thing. There was no inquiry.
Absolutely not.
And the order at page 103 for imposing the penalty on you not only refers to your reply. Let's hope you have admitted everything in your reply. I would have been satisfied that that admission is enough. But it refers to a preliminary inquiry report. How can do?
Whether, he was at all an inquiry officer to submit that report.
I give them that liberty that because that is one of the documents which is there in your show cause notice. So let's take it to be a preliminary inquiry. The law is very clear. A preliminary inquiry report, if not proved by examining the author in the inquiry, proper inquiry, that is of no value at all.
Moreover, they have to give me the copy of the inquiry.
Copy of the inquiry report. But Mr. Bhattacharya, one clarification I would like to seek from.
Yes.
We tentatively, my view is that this order cannot be sustained. It has to go. But you admittedly had given up your service from the 1st of, say, 2006, around January onward. Barring that earn leave period, which was granted to you, the other period is not regularized till now. So in that view of the matter, you have qualifying service for pension. Can we direct the government? I want a submission from you on this. Can we direct the government? We'll interfere with this to calculate your pension by treating your qualifying service till the end of that earn leave period. Other period will not be treated as qualifying service. You get sufficient pension. What do you have to say?
First thing, that voluntary retirement application, has it been heeded to at all?
It has not been headed to. They have given a explanation that because we were contemplating a proceeding against him, they have not done it.
I have not found it.
Somewhere I found that. I found that somewhere.
Anyway, let it be continued.
Hmm.
Voluntary retirement, I do not require the consent of the government. The moment I give it,
3 months because you had completed the service.
moment I give it and qualified in the years, they need not, they have to pass only order. I must be allowed to show.
And they have done that in case of one of your colleagues also. They have done that in one case of one Mr. Makhanlal Das.
That is a absolute violation of Article 50.
Okay. You formulate your points.
First thing, your lordship may kindly come to the that late complaint,
P60.
page 68. Your lordship will kindly see on the left hand side. DT,
Should furnish a
Director
detail.
of Technical Liaison, should furnish the detailed report on each point.
Hmm.
Who gave him the responsibility to make an inquiry? He was supposed to submit the report. That means, my lord, there was no inquiry. Only the notice under Rule 9 of 1964 rules was issued to me. Thereafter, what happened?
Nothing.
The order is passed after 2 years, 2007, the so-called inquiry. They no sort of so-called notice on the basis of the, I won't call it an inquiry even for a moment.
It cannot be. It's a preliminary inquiry in any view of the matter.
No, my lord, I will not call it even a preliminary inquiry because he has to
Fact
be,
finding.
he has to be appointed as an inquiry officer under the rules, whether he is competent to pass this order. And that too coupled with the long silence for 12 years. And your lordship only considers this, if this inquiry report is not an inquiry report under Rule 9, then there is no inquiry at all.
Mr. Bhattaji, let's give them that leeway. Let's say that there is an inquiry report, right from, because if you come to page 98 of your writ petition, the show cause notice, you will find that serial number 7. Serial number 7.
Yes.
Enquiry report dated so and so of so and so. This is at best a fact-finding inquiry.
Yes.
It cannot be more than that.
That's why I said, Miller, this is not inquiry
not.
in the meaning of
Except,
Rule 9.
yes, it's
But
not.
even then, let me show that. Even then, your lordship at all says that it's a preliminary inquiry or whatever it may be. What happened thereafter?
Nothing.
Rule 9 is completely given the.
Because if you come to the termination order,
Nothing absolutely.
no, they have done a blunder by referring to that preliminary inquiry report without proving it. That is the end of the matter. This order can 103. This order cannot sustain.
Exactly.
That's my, subject to what they said, that's my view.
So, Miller, first thing, there is no inquiry at all in
No.
this case.
Hmm.
Number one. Within the meaning of Rule 9 of the 1964 rules. Number two, Miller,
Yes, Mr.
I have applied for voluntary retirement. On the date of passing the order, I am not a government servant because it need not be accepted by any consent from the government servant. The moment I give it, if I qualify, then I must be allowed to go. More than one Supreme Court decision is there. And that is coupled with the punishment given. On
Dismissed.
2011.
Hmm.
As against the punishment, my lord, I was not given any opportunity to represent. They can say that 311 has been amended, but 300, even then you are bound to give it. If constitutional bench, the Supreme Court say that whether he asks for it or not, whether rule is there or not, you have to give him because that is a fresh matter inquiry report. On that basis, the disciplinary authority passed the order, and your lordship will see this is an order passed on the basis of the peace inquiry report. Then what about the
It's
Public
Putting
Service
the-
Commission?
cart before the horse.
Did you refer the matter?
It's putting the cart before the horse.
Exactly.
You can, this order, at least this court, my view, subject to what they can show. And you refer to 311. Let's say that they have done 311 too. But there has to be an indication somewhere that we are exercising the power under that or under Rule 10, that it is impracticable to hold an inquiry, not even a whisper anywhere. So, Mr. Bhattaji, one factor which I would like you to address is, say we interfere with this order. Let's forget your voluntary retirement. It's there. We interfere with this order. But admittedly, after from 1/8/2006 onwards, you had abandoned. I'm not using the word, please. I'm just only to convey my meaning. I'm using the word. 1/8/2006, you had abandoned. And then you retired from your services on. When did you retire?
Next year.
2010,
No, madam.
9, 2007.
I would be retired.
Huh?
2007.
Next year.
Next year,
May.
1925.
So at least till 1/31/37/2006, you are in service and you are entitled to all the benefits. Either it's by way of voluntary retirement or normal retirement. You will have your benefits till 37/2006. We will limit the pension till that date and we'll direct them to pay your pension from your date you have retired. We interfere with this order. What do you have to say? Where is the application for, where is the application for voluntary retirement?
Yes.
Voluntary is there.
70, 14, 9 to 39, page 70, 70,
Page 70.
70.
So we will not go into that. We will go by your period of service and limiting it to that period till you took extraordinary leave. Just a day prior to that. Till that day, we will hold that you are entitled to pension. And they will release that to you within a specified period. Until that is released, processed, you will be given a provisional pension. What do you have to say?
No, my lord, your lordship, you say, I have two problems. Okay. First, if the inquiry is not there, the dismissal order must go. If the dismissal order has gone, then my lord, I must be reinstated in the service.
But that you
Then-
have retired.
That is my, suppose your lordship is not satisfied or convinced of that matter, then what about the voluntary?
Voluntary retirement, they
They are absolutely silent about it. Just see, your lordship, my regulation, I have applied for it. If I have not gone for, you have not regularized my service, then I should have been on service.
Hmm.
But I have explained why I cannot. My mother was ill, my children were ill.
No, their contention that you have admitted to the charges, which I find it difficult to accept because what you have said, there is a clarification. And if that has to be accepted, it has to be in pursuance to an
It
inquiry.
only may not, your lordship is saying from the impugned order.
No, I'm saying from your reply to the
Huh?
show cause notice.
Huh.
It is not an admission, it's a
No, it is not
clarification.
admission of the guilt allegation.
It's a
I am explaining,
explaining, clarification.
clarification.
It cannot be an admission to that charge. And what decision you have on with regard to that VRS thing?
78.
You can just give the citations.
1977, I'm giving a soft copy.
1977?
4 SEC.
Hmm.
441.
Party?
441. Para 441.
Party.
Parties. Dinesh Chandra.
He was a district judge, my lord,
Oh.
from Guwahati. Lordship will come.
Right.
Para A,
Yes, I have it.
may I read it? please?
No need, Mr. Judge, you don't trouble.
Your lordship, is the last sentence. There is no question of acceptance of the request for voluntary retirement by the government. When the government servant exercises his right under FR 56C. Mr. Narendra is therefore right in considering this position. Even then, my lord, your lordship will kindly, they may say that matter, point has not been gone into because the learned lawyer for the other side, Mr. Day, he has admitted it. After this also, my lord, this case was relied on by the Supreme. Yes. Oh, porque tu dices como que dice algo de lo que no tengo. Muito esperado por isso.
You are relying on Sanjay Jain,
Para 14, you know,
para 14.
2019, 14, let's say 492. In Dinesh Chandra Sangma versus State of Assam, the provisions of Rule 119 of the Defense of Internal Security of India 1970 came up for the consideration. It observed, that is quoted, you know, Dinesh Chandra Sangma, the paragraph 16. The appellant has voluntarily retired by 3 months' notice, not in accordance with an express or implied term of the contract of employment, but in pursuance of a statutory rule. Expansion 2, the rule 119 makes no mention about of retirement under a statutory rule. Hence, the same is clearly out of the way. The submission to Rule 19 is superimposed on Fundamental Rule 56, has no force in this. Paragraph 16 below, the High Court committed an error of law holding that the consent of the government was necessary to give legal effect to the voluntary retirement of the appellant under Fundamental Rule 56C. Hence, the condition of the Fundamental Rule 56C are fulfilled in the instant case. The appellant must be held to have lawfully retired as notified by him with effect from 2/8/1976. It's very clear.
Mr. Bachchan, if you can come back to your voluntary retirement application, page 70. '71, last paragraph. Here, she had left it to the government. The 3-month notice period, we'll have to deem now. Because here, she had not said, I'm voluntarily retiring from a particular date. She had left it to the government. And the government did not, they sat over the matter.
Till today, we know
Nothing has been done.
nothing.
And the interesting thing here is the contentions that you have made in the year 2012 in the writ petition has not been, there is no affidavit.
No,
So
Supreme
everything
Court
is
has decided.
uncontroverted.
the Supreme Court has decided that also.
That also.
Yes.
Nothing.
This telegraph for me. We are 1993 supplementary volume 4 in court cases, page 46, para 9.
Pardon, Nasim Banu, yes. So, Mr. Vatsaji, in short, two aspects. One, if I have understood you correctly. Two aspects, if I have understood you correctly. Your first insistence with regard to the order, it's absolutely frivolous. It cannot stand.
Yes.
And the stand taken reference to the inquiry report itself vitiates that order. Now the question comes, if that order is interfered with, there is a decision of the Supreme Court says that it goes back to the date of the show cause notice. Tarula. Now, the next question that we may be required to answer is whether your voluntary application should have been treated that you are no longer in service as of 2009 when the show cause notice was. As of 2009, you are not in service because you had already retired. You had already retired. And they could not have done this order because by this, your retirement, it is a proceeding under 21, not under the 64 Act. You are proceeding under Rule 21 of the pension rules. So they could not have dismissed you from service. Mr. Bhattacharya, if you have got me,
Yes.
the beauty here is, I thought that will come. You retired sometime in 2007.
On the date of
2007.
Now, employer-employee relationship came to an end in
is no longer
2007.
there.
How could they have dismissed you in 2011? Yes, Mr. Das. How can you dismiss her? Because, Mr. Bhattacharya, this is a question of law. It's not needed, but it's a question of law. Once you are retired,
I'm no longer a government.
you are no longer a government servant. These penalties cannot be imposed upon you. And there are decisions of this very part. Yes. Now, Mr. Bhattacharya, you can please have a seat. Yes. Forget the technicalities. Tell me how could you have passed that 2011 order? I give you that order was correct in all senses. But how could you dismiss it?
After
No relationship.
retirement happened.
Huh?
After retirement, he cannot be dismissed.
Then?
But Malad, there are judgments of, as Malad has already said, Malad, that if there is any lacuna in departmental proceeding or this.
This is not a lacuna. This is not a lacuna. No. We are not remanding this back after 12 years. No.
But there are judgments of Supreme Court also. I'll.
Mr. Any judgment of the Supreme Court in such facts will never say remand back the matter. Because this is, you have victimized.
But my lord will appreciate that the petitioner has been continuously not in service, my lord. He is not in service
Now
and-
by drawing up this proceeding, you have regularized that. You have regularized. Just missed this point in the initial stage. I forgot it. Yesterday night I had formulated that. I forgot that. Now it came to me again. What I do is, will not trouble Mr. Bhattacharya. Mr. Bhattacharya, this is the case. We will interfere with this order. But as he has prayed, what I do is I'll fix this matter on Thursday next for delivery of orders. In the meantime, if they can bring on something on record on Thursday, I'll give them an opportunity. Otherwise, hearing is complete.
My lord,
I'll interfere with that. Whatever consequences are there will follow. You will be entitled now for pension till you have retired. That period you cannot. Because you have drawn up a proceeding against it. And that proceeding penalty is not sustainable. You could have only but a part of a pension, not more.
My lord, may give it a part, will
No partner.
address.
For
all-
delivery, no.
So
12,
Thursday, my lord, please-
2012 matter, we are dictating,
No, my lord,
not
one
dictating the order
opportunity may
today.
be- On Thursday, my lord, I may be allowed to.
I'll give you 10 minutes. If you can satisfy me, satisfy me. Otherwise, what we have said, we are interfering, consequences will follow. Mr. Bachchaji, anything more?
Since your lordship is taking that view, my lord, there is a constitutional bench decision. Your lordship knows that 311 has been amended. Second so-called notice,
Not
absolutely. But even then, the constitutional bench said that whether it is in the rule or not, it is a violation of the principle of natural justice. So it was not, it cannot be such, Rumpun order cannot be such.
Yes. And your case is on a better footing.
Yes,
Yeah.
I am in the better footing, no
You're on a
doubt,
better
but
footing.
I did not want to leave it to the chance.
Yes,
So that your lordship can
yes.
exercise your lordship's mind
Hmm.
on all aspects. I give a long rope to him. Let him justify this order.
That's
Let him justify that this man was his inquiry officer. What is this nonsense?
Or you come and satisfy us that
75 years
Aznur
of
Rahman's
illegal-
that report is a report under 9, rule 9. Come and satisfy. We'll ask Mr. Bachchaji, sorry. We'll tell Mr. Bachchaji sorry. There is no inquiry.
It is absolutely without jurisdiction. He is nobody.
And that order, you referred to an inquiry report without having it proved in the, and see, you could not have issued this notice under rule 9 without referring to the pension rules, because she, on the date of issue of the show cause notice, she was no longer your servant. No relation was there. Did you
Master-
continue
master
her
and
in
servant
service?
relation- Master and servant relation is no longer.
No longer then.
You cannot do anything to it.
So that period of extraordinary leave, now we will have to deem it to be regularized. She'll be entitled to full pension. Test it. This is our tentative view. If you can change it, or test it.
That is another punishment to me. Non-regularized.
No, we will not going to. We will say everything till the date of your regular. I'm sorry, this thing just yesterday night I formulated. Now when I saw my note, I recollected. I forgot this in the initial stage.
My lord, your lordship will see the frustration of my client is a lady. She said, let it go. I am no longer interested. First 12 years, they have not submitted the, this is a misconduct on behalf of the government.
Mr. Das,
Yes, my lord.
she has committed a misconduct.
Yes,
That she left her services without taking a prior approval.
Yes.
A professor
Yes.
should not have done it. Now you, by way, you have acted in passing the impugned order, and this matter being here from 2012, she has suffered more than that.
It's a question of livelihood. You know?
She has suffered more than.
My lord, I have another point.
Yes, yes.
regarding listing, my lord,
Wait, just Mr.
This is
Bachchaji.
outside the case, outside the case. Would your lordship kindly ask the registrar, the case of livelihood, how long it is pending? There are
Mr.
many.
Bachchaji, once I assumed this bench, I asked them, what is my power? Then they told me that I can list matters according to my wish. And the first thing I did was, you will find in my cause list from the day one, matters from 2012 onwards, bench to matters, practically it's over. The matters I cannot take up, those are there. Others, practically we have dealt with. Now, every day, first 10, 15, 20 matters would be matters of 2012 till 2019. I've given them the cutoff till 2019. And I'll do my bit. And assistance from the bar, we will finish it off. What has happened, has happened.
Oh, my lord, what I say,
this matter cannot be taken lightly. They should understand that we are suffering. I can't do, my lord, anything. It is not within my jurisdiction.
I know that.
I can only complain to your lordship. We are ashamed of it. How this government is running. Successive governments are going and going. And they are not at all sorry. He does not express anything. Why? I will be.
Mr. Bhattacharya, I understand your
If your
anxiety.
lordship wants to call them here, I don't have any of them. Let them come and explain to them.
What they will explain? Nothing. Same thing. And those people who have done it are no longer, maybe in the world also.
Yes. No, that I do not know, but they are not inside.
So, Mr. Bhattacharya, you are here. Fine, I'll love to have you here. If you're not here also, this is my view.
No,
We're interfering.
I'll be here.
Subject to what you can,
Yes, sir.
we'll give you some time.
Yes.
This will be the first matter. I don't want to keep Mr. Bhattacharya
yes.
waiting. This will be the first matter on 25.
Third, you know.
25.
25. Hope it's not inconvenient to you.
Is it possible on 23rd?
Yes, yes. 23rd, fine, 23rd. 23rd, Mr. A.K. Bhattacharya, the senior counsel. At length, Mr. Bhattacharya has completed his submissions and has placed on record decisions in support of its such submissions. Mr. S. Das prays that he be given an opportunity to make his submission in the matter. He is not instructed. This court has viewed, has perused the materials available and is materials available. For the ends of justice, Mr. S. Das is given an opportunity to make his submissions with regard to the validity of the order dated 37/2011. List this matter again on 23/1/2024 for delivery of orders. However, before such delivery, Mr. Das shall be given an opportunity to justify the order dated 37/2011. We'll pass orders on that. There's judgments, I'm keeping it on record.
Item number 4.
May it please your lordship. Lordship, senior is out of station, my lord. My lord, kindly,
Who is appearing for the, you are for the petitioner?
yes,
Who
my,
is appearing for the bank?
I don't know one.
Madam,
My lord, on the last,
madam, this is a matter of 2012
yes, my lord.
and you had expressed urgency in this matter. That is how it is before me today. Now tell me, you are in the case?
No, my lord, I'm not in the case.
Where is Mr. Katajuri?
My lord, he is in Tezpur, my lord, engaged in some another case,
We'll have it on Tuesday.
Tuesday.
And I want the inquiry report.
And
Then-
my lord, in the last 3-4 days, my lord, no one appeared in the respondents.
Okay, they need not afraid. They have done their part. They have terminated your services.
Okay.
It is for you to justify
Okay, my lord.
how the order is bad. Now, I want the inquiry report because see, you have submitted even a reply to that inquiry report. That inquiry report is not on it. record. So we will have it on,
My lord, on
Mr. Katajurika is coming back when?
my lord, on he's coming on 20
20,
on Saturday.
Saturday.
My
We
lord,
will
kindly
have
please-
this matter on
22 Monday, my lord.
24,
24. Okay, my lord. Let me oblige.
on the prayer of Mr. DCK Katajurika. List this matter on 24/1/2024. On which date the Learned Counsel for the petitioner shall place on record a copy of the inquiry report dated dated 30/9/2009.
Next.
Next.
Item number 5.
Yes, Mr. Roy,
My lord,
gone through it.
petitioner, lordship may, I think, my lord, it's better lordship will dismiss the. case
I'll
for
not
pet-
go on merits. If they have
No,
something, they
lordship,
can come
lord,
back and
that's-
say.
It's better, my lord.
Otherwise, a touch and go case. Nothing is there. I've gone through it. Only confusion when I started off was whether, once you have written off, whether you can come back and drop a proceeding. But I find that the order of writing off itself says that the responsibility should be placed. And you have categorically stated that the damage was taken out.
Yeah.
And thereafter, the shortage was only questioned. So in that view of the matter, maybe nothing is there. But anyway,
Lord,
will not dismiss it on merit.
It's better. I was also suggesting this the other day, but.
Anyway,
unfortunately.
now 2 days, it's
Not-
there, nobody
no.
is here. Maybe they have lost interest. None appears for the petitioner on call. On earlier 2 occasions when this matter was listed, there was no appearance on behalf of the petitioner. Full stop. Mr. P.K. Roy, the senior counsel, assisted by Mr.
SK Chowk.
S.K. Chakraborty, appears for the
126.
for the respondent, Food Corporation of India. Full stop. In view of the above, this matter stands dismissed on account of non-prosecution.
Obliged.
Item 6.
Yes, LIC,
My lord, on earlier 2 episodes, petitioners did not appear.
I know that. But what happened to the CBI matter?
The CBI matter, my lord, it is so far he has got acquittal.
Acquittal.
No, my lord, it is one of the witness.
What happened to this?
not
What is
acquitted.
the finding of the criminal court?
Not honorably acquitted as instruction.
No. What is the finding of the criminal court with regard to that opening of the account and deposit of checks?
My lord, this instruction I have not.
Anyway, he is not there. Last occasion
Earlier
also
two
not there.
occasions- Earlier 2 occasions also did not appear. We have
Same order.
obliged.
Dismissed.
Obliged.
If it comes back, we will restore it because that aspect, if the criminal court has come to a conclusion
On the same,
contrary to
same
what-
evidence.
on the same evidence, then maybe he will have a matter. But let him come.
Obliged.
Item 7.
May I please your Lordship, this brief has been taken away from us, Lordship. We are no more engaged.
Mr. Pothakur is no longer there.
Lordship. Obliged.
You have given due proper receipt and all,
Lordship.
then we will not record your name. We will say none appears.
Sir.
You are appearing for me. Comment.
Lordship of my lordship.
None appears. You can leave.
Obliged.
None appears for repetition on call.
If you have less lordship.
The Mr. MS A Talukar appears on behalf of the respondents. It is seen. The petition by way of the present petition has prayed for a regularization of his services as lower division assistant under the respondents. The petitioner was engaged on ad hoc basis for 3 months while as LDA while an order dated 19/1/1996. It is projected in the writ petition that such appointment of the petition, such engagement of the petition was being extended from time to time. The petitioner purportedly appeared in a selection for the post of LDA cum typist in the year 2001. And it is the contention in the writ petition that such selection was not taken to its logical conclusion. The writ petition was filed 11 years after the holding of the said selection. In that view of the matter, no direction can be issued at this distant point of time for having the said selection process taken to its logical conclusion. Full stop. The petitioner, the other prayer of the petitioner is for his regularization in service. Full stop. The petitioner has not brought on record any material to justify that he was working against a regular vacant post and was so recruited. A process of selection. Mere completion of a long period of time will not on its own, on ad hoc completion of a long period of time, service on ad hoc basis will not by itself justify the prayer of the petitioner for a direction for regularization of his services. However, as none has appeared for the petitioner, this writ petition is dismissed for non-prosecution.
If you have less lordship.
Item 8.
Mr. Das,
Lordship,
you want the promotional benefits of assistant inspector of, sub-inspector of police.
Lordship, whatever Lordship,
What happened will come. 2013 matter, we don't want to delay it further. Just show me how you are entitled to that.
Lordship, one thing is Lordship, in this matter, Lordship, since last long time, no communication with my client, Lordship. So, if possible,
Then you
Lordship,
withdraw it.
day after tomorrow.
No. Nothing doing.
So, at
I am
two,
ready.
at
You
two.
may not be ready, I am ready.
Lordship, act two, Lordship.
No. Now, just show me
Yeah.
that order. I'll tell you your facts then.
Yes, Lordship.
You were imposed with a penalty, right? You come up before this court. This court interferes with, send the matter back. Thereafter, you were given a penalty of withholding of one increment with cumulative effect.
Yes, Lordship.
Then you did not challenge that anyway. Then the authorities on their own, the appellate authority reviewed that penalty without hearing a penalty of reversion to the post of, to the rank of constable.
Constable, Lordship.
You challenged that before this court.
Lordship, here, Lordship, the
No, wait.
last order.
No, wait. You challenged that before this court. This court interferes with that. Fine.
Yes.
But your case is that the promotion that was done, exercise that was done in
Yes, promotion, 29/8/1998, Lordship.
98,
Yes, Lord.
that has to be, that was stayed on account of the fact that there were disciplinary proceedings against you. Now, with that disciplinary proceeding ending with a penalty, how can that promotion, which is under seal cover if you hold it, can be given effect? Just satisfy me.
Lordship, one thing is
At
that-
2 o'clock, you want it at 2 o'clock? This issue, just satisfy.
Yes, Lord.
Otherwise, nothing.
Yes, Lord.
2 o'clock, 2000.
That's all right.
Item 9 and 10.
My pleasure, Lordship.
Hmm.
We challenge the election and appointment of the private respondents in the post of Sohayat, also post of Sohayat, under it.
This is a selection of 2013. We are in 24. Keep that in mind, 11 years. Now show me the mala fide. Mala fide in that selection.
In fact,
The
petitioner-
petitioner has already been appointed in 2021. He has been appointed. He has got the appointment. I have the appointment order.
Then
no, I have no less.
Very good.
Actually, I have no.
the second exercise, you got it. Your only allegation here is there was no select list published. But you again say that there is a merit list.
Kindly come to serial number 10.
Pranab Borwa. And the other one,
No, other one, I don't. have
Roman
the-
Singh.
Roman Singh, I don't have the instruction.
I have no contact with
But
my client for the last.
Roman Singh and Roman Singh, that case is connected with other matters, my lord. WPC 2423 of 2013. All other cases have been disposed of as the petitioner did not face
Withdrawn.
those petitions.
Other cases
At
are
that
withdrawn.
So here, what is there? Tell me.
What was that?
Forget this.
Now he has got the appointment, my lord.
Now he has got it, you forget it. Now you stick to your case.
Yes, my lord. So my basic grievance was that, my lord.
Hmm.
See, my lord, kindly come to the advertisement, my lord.
Hmm.
At page, page 20, my lord.
Page 20.
Yes.
Hmm.
Roman.
Hmm.
Yes, my lord. So, my lord, here, 10 numbers of post of Sohayat, my lord, and the qualification was class 8 or HSLC equivalent. Past candidates are eligible for further ITI qualified candidates will be given new weightage.
Hmm.
And that experience column, my lord, at
Hmm.
point 4, candidate must have 2 years work experience in power station and LDPS.
Hmm.
Now, my lord, I belong to general category, my lord, and I have been working there for last 10 years before I have applied.
Hmm.
And if at all, my lord, the experience has to be given weightage, my lord. I deserve, I have a more.
No, where
better-
is the weightage given in the advertisement to?
That's we don't know, my lord, because.
No, in the
says
advert,
that
forget what we don't know, but in the advertisement,
Yeah,
where is the criteria that weightage will be given to the service?
that they have not published, they have not, my lord, made it public, my lord.
You are making a claim.
Yes.
We have the advertisement before us.
Yes,
That is the Bible now. Where is that criteria that weightage for the number of years will be given in this manner?
my lord, then, my lord, my lord. will
It
come to
only
their-
says ITI pass candidates would be given weightage.
Yes, that's correct.
Beyond that, there is nothing. So the first point that the advertisement violation is not there. Because it requires only 2 years experience. Beyond that, it does not say anything.
That is the minimum. my lord.
Minimum.
Yes.
And whoever crosses that minimum are similarly placed. Provided you have an ITI qualification, that will give you a weightage. They'll maybe give some.
Desirable.
But here in this 10 posts that have been filled up, none have got
None
IT.
have got idea. Yes.
Now, second one.
My lord, yes.
Yes.
Yes, well, kindly come to their, my lord, affidavit in opposition, my lord.
Hmm.
Uh, by filed by the general manager,
Hmm.
NTPS, at para 8, my lord.
Hmm.
That with regard to the statements made in paragraph 10 of the resolution, the deponent respectfully states that the recruitment was done for 2 categories of candidates. One category having ITI pass candidates, which was sponsored from Employment Exchange,
Hmm.
and the other category having 2 years work experience and minimum educational qualification is rated up to class 8.
Hmm.
However, ITI pass candidates sponsored by local employment exchange, 2 years work experience was not mandatory.
Hmm.
Further, the selection of candidates was done on the basis of merit, 100-point roster system of the government was.
Hmm.
Now, my lord, this roster was,
You come
my
to, huh?
was not
You
followed.
come to para 9. The last line. Para
Yes.
9, page 6, last line.
Yes, my lord.
The deponent further
Respectfully states that the marks were allotted to the candidates on the basis of the physical fitness, viable experience, etc., and therefore due select list was prepared, and appointment was given on the basis of merit after following 100-point roster.
Where is your reply to this, contradicting this position?
In my affidavit reply, my lord, I have stated, because, my lord, what the rules of the game that were not.
Oh, that
followed.
affidavit reply, it's here, yes.
It was not highlighted, my lord,
Fine.
earlier. But again, my lord, they come to, my lord, the one point, my lord. In their affidavit only, my lord,
Hmm.
kindly see para 7, my lord. Because I allege, my lord, they have changed the rule of the game after the interview process is in.
No,
we have
what
followed.
was the game that was changed?
That we don't know, my lord. How they are going to, my lord.
How can you on air say something was changed when you don't know
No,
what
but
the
they
change?
stated, my lord, kindly say para 7, my lord.
Okay, come on.
Para 7 of the affidavit,
Hmm.
that with regard to the statements made in para 7, 8, 9, writ petition, the deponent respectively states that altogether 56 candidates, including the writ petitioner and the private respondents of the writ petition, have appeared in the interview, including physical fitness test, in pursuant to the vacancy notice dated 11/10/12. The interview was completed on 27/10/12, and thereafter a general merit list was prepared, and thereafter the final select list was prepared for appointment as Sahayaks from amongst the locally sponsored candidates, 100 as per 100-point research. And, my lord, prior to the, I'm sorry, my lord, prior to that, kindly come to para 6. Para 6, my lord. Yes, para 6, my lord. May I read, my lord? That with regard to the statements made in para 5 and 6 to petition, the deponent respectfully states that after receiving approval of the MD, Assam Power Generation Corporation Limited, for recruitment of 20 numbers of Sahayaks in NTPS, and out of 20 numbers, 50% of the posts, 10 posts are to be filled up through direct recruitment amongst the candidates possessing ITI certificate in the discipline of electrician, wireman, mechanic, fitter from government of or government recognized institute duly sponsored from local employment exchange, and the remaining, this is important, 50% of the Sahayak, that is 10 posts, are to be filled up from such persons who have been directly recruited by the NTPS authority having minimum experience of 2 years
Hmm.
in NTPS.
Hmm.
Subject to selection by the selection committee.
Hmm.
A vacancy notice dated so and so was issued for filling out 10 posts of Sahayaks from the candidates having 2 years of experience at power station in NTPS. The deponent further states that after issuance of the vacancy notice dated 11/10/12, the guidelines dated 21/11/12 for recruitment of Sahayak in NTPS has been prepared by the deponent, and the same was forwarded before the chief general manager. That is the thing, my lord. And after approval of the said guidelines, the deponent by an office order dated 27/11/12 constituted a selection committee to conduct the interview for selection of 20 numbers of posts of Sahayak.
No, now tell me, what prejudice this would have caused? This was applied equally to all. You come to page 10 of that affidavit, that merit list.
Yes.
Hmm?
Yes.
You are there at serial number 50.
Yes, sir.
I have scanned the writ petition subject to my,
That is
Thing.
correct.
you have not alleged anything that this placement of yours is not proper. You have accepted that. Roman Singh is senior to you, mean merit, serial number 10.
Yes,
He missed out because there were other OBC candidates above him. You are a general category candidate.
Right.
And the list is at page 11.
yes,
And you have not made any averment as to the placement made in here was wrong. Nothing is there. That be of the matter. At this distant point of time,
Yes.
in absence of any cogent material, how can we interfere? Just for the matter of saying. It's all your views. And you also don't know what was changed. So let us give it a quietus. But Mr. R. Chakraborty, the Council for Decision. Also heard Mr. You are appearing for Mr. Nath?
For respondent number, Lordship,
1, 2, 3,
1, 2, 4 and 5.
1, 2,
1, 2, 4 and 5.
4 and 5.
5.
3 also BS director. Is, oh,
3, my lord.
1, 2, 4 and 5.
5.
Also heard Mr. S. Sharma,
Especially.
SP Sharma, appearing for the respondent number 3. The petitioner has by way of instituting the present history. Assailed the appointment effective in case of the private respondents wide an office order dated 22/2003. Full stop. Just I'm writing down the facts, just
Yes.
hear me out.
yes, sir.
The Namrup Thermal Power Station under APGCL Namrup had quite a vacancy notice dated 11/10/2012 invited application for filling up of 10 posts of Sahaya available in the said power station. So, the said advertisement had in addition to prescribing the academic qualification, had required that candidates to be eligible for applying must have 2 years work experience in power station at NTPS. Full stop. The petitioner, having fulfilled the academic qualification as well as the experience criteria, had submitted his applications for being considered against that set and post. Full stop. The selection with respect the respondents thereafter allowed the petitioner to participate in the selection process, which included a physical fitness test as well as phonics. Full stop. On conclusion of the said selection process, the office order dated 22/2013 came to be issued. Full stop. As projected in the writ petition, it is the case of the petitioners that the office order dated 22/2013 was not so issued after publication of a select list. So it is the further case of the petitioner that he, having more experience than the private respondent, he should have been preferred over the said private respondent, and having not done so, the said entire selection process stood vitiated. Full stop. It is further the case of the petition that the selection process was not so conducted by applying a disclosed criteria. The respondents have preferred an affidavit in the matter and therein have laid down the procedure followed for such selection in pursuance to the advertisement dated 11/10/2012. So, it is stated in the such affidavit that in pursuance to the such selection process, a merit list was first published wherein the name of the petitioner as well as the private respondents duly figure. Thereafter, by following the merit position as well as the undergoing roster system of the government of Assam, a select list was prepared and therein, basing on the merit of the petitioner, he was placed at waiting list position number 10. The persons who figured in the merit list, so prepared basing on merit as well as the reservation applied till the 10th position were offered appointment and they were so appointed by the impugned order dated 22/2013. So, the petitioner has basically has in the petition challenged his non-selection on the ground that the experience garnered by him in the Nabruk Thermal Power Station has not been given any weightage during the selection process. The said issue has to be examined in the light of the advertisement issued on 11/10/2012. In the advertisement, while prescribing that the minimum educational qualification to be possessed by a candidate desirous to apply in pursuance thereof is class 8, is still reading up to class 8, it was mentioned that HSLC or equivalent pass candidates are desired. Further, a weightage was given to ITI qualified candidates. With regard to experience, the only prescription made was that the candidate so desirous to apply must have had 2 years work experience in power station at NTPS. Full stop. They said advertisement does not provide for granting of any weightage in the selection for the candidate. Weightage in the such selection basing on the length of the service of the candidate so applied. The call letter given to the petitioner available at Annexure 7, page 21 reflects that the selection was so conducted basing on the physical test as well as a viva. So the petitioner in his writ petition has not alleged any malafide against the selection committee members and has also not questioned either his placement in the merit list vis-a-vis the placement of the private respondents. The private respondents have been in service in pursuance to the impugned order dated 22/2/2013 till date. The petitioner having not brought on record any material to doubt the placements of the petition of the private respondents in the merit list and also not having questioned the marks allotted to him in the said selection process. The other contentions of the petitioner cannot be accepted. Accordingly, this court, accordingly, I am of the view that the office order dated 22/2013, prepared in pursuance to a merit list published after a due process of selection, requires no interference. Accordingly, the writ petition is without any merit and the same accordingly stands dismissed. However, there would be no order as to cause. Sorry. A Roman Singh, Khali, same order, everything would be the same.
So Roman Singh was 12th in the waiting list.
But I've taken it up. Roman Singh,
12th,
merit
number-
position
10th,
and the wait list 2.
12th.
Same, 46.
Well, is 2.
Sorry, Mr. Chakraborty.
It's okay. Well,
Item 11.
You can have this back, Mr. Nath. Yes,
When I was doing the pendency of writ petition, he expired, madam.
I know, then the family stepped in. Fine,
Finally,
fine, we accept that.
and what happened in the criminal case, the appeal was also dismissed, madam.
That's what I was about to ask you. What is left here?
Even then, my grievance was the
See,
inquiry. Because
beyond reasonable doubt, if a person is convicted,
yes,
preponderance of probability is down below.
understand, madam, but only the inquiry report was never forwarded to me later on.
Fine, that is, you argue now. We are giving you an opportunity, argue on the inquiry report is at page 26, the inquiry report is there. I have checked that and I have found the findings at page 27.
27, madam.
And the categorical finding is that you admitted to everything.
He admitted he made the estimate requirement.
And you have not, in your writ petition, countered that.
Yeah, understand, madam. Because there was admission on his part, my lord, in the,
Rightly, wrongly, a finding is there.
yes,
It may be totally perverse, but you will have to bring on record materials. You have not even touched that.
actually that, I think, because it was not made available.
Fine, you got it when you filed the writ petition. You should have dealt it in the writ petition. We would have considered it. Forget the disciplinary authority.
But that.
And see, the beauty here is, the finding is everything admitted. Page 27.
27, yes, madam. He admitted he issued the order to and so supply material. He admitted.
And there was nothing taken from the upper authority, higher authorities. He had done it on. And I've gone through the order of the appellate court, criminal bench.
Yes,
All these allegations proved,
yes, but there also that he was at, that was admission. madam.
and he admitted to everything.
Yes, I understand.
You have an order of that appellate court.
That. That file has not by, let me see whether it is there or not.
My Lord Justice B.K. Sharma's order.
Yes, ma'am.
Anyway, I have it with me.
Anyway, about Molo, see, no longer there, madam. Expired, madam, long back, madam.
Only no, just take it. Heard Mr. P. Kotoki, Attorney Counsel for the petitioner. None appears for the Panchayat and Rural Development.
I've informed them.
You are appearing.
No, my lord, I've informed them, but their name is not shown in the cause list, my lord. That's why. I've
Who is
informed them that they are
Mr.
coming
Who is appearing?
as doctor, my lord.
S. Doctor. Also heard Mr. S. Doctor, Learned Standing Council, Panchayat and Rural Development for the respondents. The petitioner, by way of instituting the present proceedings, has, I think, Mr. That's it.
Because when the criminal case we have lost, my lord.
Nah, first thing I checked up was that.
Yes.
When I found that it's gone, then there is nothing.
Yes, yes.
Has assailed a
And we have,
notification.
it's better not to praise, madam. Otherwise, what-
Not to press.
There's no.
On the, I heard Mr. So, Mr. P. Kotoki, Learned Counsel for the petition. Also heard Mr. S. Doctor, Learned Counsel, appearing for the Panchayat and Rural Development Department. Mr. P. Kotoki, in his normal fair self, has submitted that the petitioner, facing on the same charges, was also subjected to a criminal proceeding. The trial court had convicted the petitioner while an order, judgment and order dated 19/7/2012 passed by the special judge Assam in special case number 7 of 2010. The said judgment was carried upon appeal before this court by way of filing criminal appeal number 141 of 2012. The said criminal appeal, upon consideration of the issues arising in the matter was dismissed by this court. Why? Can you just give me the order date? The order date. Madam, you can just give it to her or give it to my bench here. Date.
Camille appeal, ma'am.
Huh?
Camille appeal, my lord, actually, my noting, my, it was there at 26/3.
26/3, 2015.
15, ma'am.
Madam, you just check it up
Yeah, no,
and give it.
yes, let me see in the report, ma'am. It everybody updated also, 2015, ma'am.
No, it's updated, it's there. I just, because when I downloaded the order, that
Yes.
date did
Yeah,
not.
it was equal.
Kelly,
Till 141.
27. In view of the said opposition, the charges against the petitioner having been against the husband of the present petition having been established, it is that he be permitted to withdraw the present petition. The present petition accordingly stands, accordingly is permitted to be withdrawn. No, the present petition accordingly stands dismissed on withdrawal. Just give that date.
Yes, yes. Actually, one point was involved in sanction point. That was not taken in a trial.
Sanction point was not taken. You argued that before the honorable single judge here, but single judge did not accept.
Yes, it was not taken earlier. Yeah. Then the matter would have been
Dismiss, different.
real. Anyway, bad luck. Well, although he has already
Gone.
left his goal point.
Item
Anyway, he's
12,
getting,
sorry.
family is getting pension.
Item 12,
Your lordship.
Yes, Mr. Dora.
Lordship, if I may go through the facts very briefly.
My lord, may I submit one thing? My lord, the matter pertains to the termination order issued by the NSM, my lord.
Hmm.
So NSM, my lord, they have not been shown in the cause list. So I tried to contact them because the standing council NSM is not there, my lord. Termination notice by the NSM, my lord. National Health Mission.
How can we come in your aid now?
Lordship, compensation can be granted.
We will not grant it. For that, you will have to go and establish your case before the civil court.
Lordship,
Can I enforce a contract for service, of service?
Lordship, I have a Supreme Court case, I will send depending on.
Just a moment, Mr.
Yes,
Let's see. Which is that one?
AP State Federation Corporation, Spinning Mills Limited and versus.
That industrial tribunal matter.
Pardon, Lordship. Termination being punitive in nature. And ours is punitive, Lordship. Lordship kindly comes up here, paragraph 5 of the judgment. Our termination order was purely punitive, Lordship. Lordship just goes to the order, Lordship will find. It has barred me from any future employment. The present case, Lordship,
Now, your this present case, your termination order is of
7/9/2011.
7/9/2011. To what time was your contractual engagement?
Contractual, that was continued automatically, Lordship. It was initially a period of, for a period of 6 months. But your Lordship will find I joined service in 5/10/2009. The department didn't apprise anything, didn't take any appraisal steps for renewal.
I know that.
7/9/2011, I was still continuing. Since the termination letter was there, dated 7/9/2011. That means I have been automatically continuing.
What happened to the criminal case?
I think it's still going on because the petitioner, I had been gone to the CID headquarters in Gubari. Around
No
one
charge sheet has been filed.
1.5 years back.
No charge sheet has been filed.
No, not yet. Lordship, I just want to take your lordship to two documents. If lordship kindly come, it will take only 5 minutes. Page 45 of the petition, lordship.
Hmm.
45 of the petition, lordship will find.
I know that report which says that it is by
Yes.
the bank.
Yes.
And then next,
And the termination letter, the whole termination.
no,
letter-
we interfere with both. Still, what benefit? If you want a compensation,
I've been denied pay from April 2011. So living
April 2011 till
2011.
7/9. That maybe we can provide you till 7/9.
there, that I want to hear.
That much period we can give you.
Yes.
Beyond that, no.
No, beyond that I don't want also because reinstatement is impossible and beyond that it will also be. It will not be
Okay.
correct on our
They are not here.
lordship.
We will dispose of this writ petition, giving you a liberty to approach the authority, show this Supreme Court judgment, annex it, get your order from them for that period from April, because your contention is that you were not allowed to join,
I was not allowed to join.
right? And they will take a call. We will direct them to you to submit a representation. Or you will have to wait till the NHM authorities come.
Can it be listed on under the?
I'll do that. It is submitted at the bar. That the name of the council or the respondents, that is the
That's one number one.
National Rural Health Mission, respondent number 1, is not reflected in the cause list. Also, accordingly, registry is directed to list this matter again on Tuesday, 23/1/2024, reflecting the name of the Standing Council, NHM, body respondent number 1, body respondent number 1 and 3. But Mr. D. Dwara, open at Mr. D. Dwara, the council for the petition. On
Okay.
Tuesday, we will finish.
Most obliged.
So your salary is dimmed from period April.
April, we do not want that also because April there is a dispute.
Dispute.
Dispute, we wanted from,
Chennai,
from Chennai.
from May.
No, lordship, not from April, but it would be best if from 4/1/7/9/2011, that is the date of the termination order. To the date we received the termination letter, that is in the court of my lord, my lord Justice V.P. Kotuke as it was.
That you're not going to.
That has
That
been
you're not going to.
reflected in the order, lordship.
No, that you're not going to. Order of termination, even if subsequently submitted, is submitted. That we will not.
Then,
Anything between that period, before 7/9, anything is there, tell me. After that, no. Even I'll not give you till the time, if you take a claim, that till the time my services are, the period of contractual engagement is there. In this case, we will not even come into.
because that has not been specified.
So-
This is vague.
So,
Much obliged, lordship.
so this is dismissal. Only formality. We'll close it today. What is there? I'll give you a liberty. If you have anything, you go before the civil court. Take your rights.
My lord, if the standing council arms, at least if I get, I have been working as a.
That you forget. That they are not going to consider.
That
Okay, fine.
few
23rd.
months at least.
Dismissal postponed till 23rd. Okay, fine.
All right.
Item number 13 to 17.
Yes. What do you have to say?
My lord,
Only tell me a straight answer. Is your certificate genuine or not?
That is a matter which is required to be proved in the discipline.
You have not done. I'll ask you, go before the civil court, prove those things.
The
Because why I'm telling you, in the inquiry, there were 2 witnesses who had gone to the SEBA office and collected that documents. You did not cross them.
My lord, when we discuss a disciplinary proceeding, this honorable court, very recently, my lord, the mode and manner in which the inquiry has been held is what will be considered by this honorable court. What will not be considered by this honorable court is the sufficiency of the evidence.
We are not even on that.
Therefore,
We are on the question of opportunity.
my lord,
Your case is that an opportunity was not given to you.
my case is not only limited to that. Your lordship, I have got around 5 grounds on which
Go
the
ahead.
entire case is based. The proceeding is one which is held under the CRPF.
Forget it.
rules.
First and foremost thing,
My lord.
the underlying factor, whether that certificate is genuine or not.
My lord, when similar matters have come up before this honorable court on the question of the genuineness of a certificate, this honorable court has not gone into that aspect of the matter. Why I am not making a statement is one issue. I'm not making the statement because that is something I will need to prove if a proper inquiry is held by them. My statement today here may prejudice my client on either of the two sides. And there is a statement made in the writ petition which says that I have produced documents which were supplied to me by the
By
either
the
concerning.
SEBA, from the
But
SEBA,
the SEBA never gives me a certificate.
no, by the SEBA, and the date therein
Madam,
is a date before even the doubt had arisen. A date of the authorities.
this entire, those documents were not given by me. They have admitted they have received it by post.
That's it.
That is
They
their
say
document.
that they
Those
cannot believe
documents,
it,
those documents have been produced by their witnesses.
and the
And
other,
their witnesses producing the document, the inquiry officer holding that these are documents which are beyond, previous to the date on which the doubt arose. If that is the case, was it my document which I required?
no,
required to
subsequently
be-
they had the inquiry made. 2 witnesses were produced who had gone,
If
no,
the-
just satisfy me, this is some doubt. Clear it. 2 witnesses had gone there.
Yes,
Those witnesses deposed
yes.
that we went. The facts they deposed. You did not question me.
I did not cross question them is. Therefore, my lord, my very first ground is the inquiry officer being biased. Was I allowed to cross examine?
Where have you
Would it-
taken that plea? During the proceeding, where have you taken that plea that the inquiry officer
But
was
the
biased?
inquiry officer, if he is an unbiased person, he will take down everything that is put before him. If he is a biased person, he will leave out half of it.
Fine, Mr. Mozumdar. Where did you take that plea that you were not given adequate opportunity during that inquiry?
That during that inquiry, if I am supposed to take it before the inquiry officer himself, if he does not record it, that is where the biasness comes in.
No.
I cannot ask him
If
to
that
record.
is not, you will have to come out and take the matter to your higher authority.
Madam, this matter was, lordship will see in a department inquiry in a discipline force. The manner in which an inquiry is held is not unknown, my lord.
Okay, your first point.
My first lordship will think. The lordship will allow.
Decision in one will cover all.
Yes, yes, sir.
Lordship may like to have the CRPF Act and rules.
Assembly. How long will you take?
My lord, in fact, I can give a judgment which is covering almost all the points that we have.
Fine, then why waste time? Give me that. And tell me the grounds. First, you give me the broad grounds.
Violation of Rule 27. D1.
Roman one or normal one?
My lord,
Normal one.
normal one.
Then?
Small d number 1.
Hmm.
Thereafter, my lord, that section 11(1) referred to by the disciplinary authority.
Section 11(1) of the CRPF Act,
CRPF Act
1949.
1949 will not govern my case.
Because you have not yet taken that something oath or something like that.
No, because I was not a
Affirm.
member of the force when I submitted the certificate. Even whenever I submit the certificate, I'm not a member.
Great. Then next,
Then lordship would have the absence of a presenting officer.
Ah.
The
and that
inquiry
finding
officer-
is there that you were offered that you did not accept it.
Which one?
that finding is there, that you have offered a chance
Who?
to have a defense
Well,
counsel.
am I to be offered a chance to have a presenting officer?
No. The,
My ground is presenting officer.
okay,
The
presenting,
inquiry officer acts as a presenting officer, calling in witnesses on his own without an
Presenting
application
officer.
from any ground.
okay, done.
And
Sorry, I got it as a
No.
defense assistant. Okay, fine.
that is one of one of the ground that I was not allowed to. And that is where the biases would all come in, my lord. And thereafter, lordship will have in their affidavit in opposition. They have even gone to the extent of saying that the offer of appointment is also forged. So the entire biases of the respondents in dealing with the whole case.
But that was not a charge.
There was not a charge.
Forget it.
Now, lordship will kindly have the memorandum of charge. Page 14. The undersigned proposes to hold a joint departmental inquiry under the provisions of Rule 27 of
You can come to
CRPF.
page 50.
My lord. Page 14, my lord, I'll just.
That's the,
Page
yes.
28 of the rules.
Hmm.
29, Rule 27, D1.
Hmm.
Where two or more members of the force, including those on deputation to the force, are concerned in any case,
Hmm.
the Inspector General
Hmm.
or any other authority competent to impose the penalty of dismissal from service on all such members of the force may make an order directing that disciplinary action against all of them may be taken in a common proceeding. Such orders shall specify. This is number 2.
Hmm.
The authority which may function as the disciplinary authority for such a common proceeding, the penalty specified in the table of sub-rule A above, which disciplinary authority shall be competent to impose.
Hmm.
Whether any such disciplinary authority shall hold the departmental inquiry himself or may designate any other inquiry officer
Hmm.
for that purpose, and that the inquiry shall be held in accordance with provisions of sub-rule A and sub-rule C.
Hmm.
There is no such order available on record.
Hmm.
They have never passed that order at any point of time. Even in their affidavit in opposition, they do not refer to any other order.
Where is your pleading to that?
My lord, please. Page 9, para 18. I'm sorry, my lord. I'm sorry. I'm extremely sorry. Not that. Not that. Yes, page 8, para 16. And page 7, para 11. Worship may like to have their reply. Their affidavit in opposition. Para 8, they have replied to at page 11. Para 10. That with regard to the statements and the averments admitted in paragraph 8 of the petition, the deponent begs to submit that the contents of the petition is devoid of merit in this regard is submitted that as per the findings of the inquiry officer and the documentary proof annexed in the department proceeding, the petitioner was found ineligible and unqualified.
You are reading?
I'm reading page 11, para 10 of their affidavit in opposition, which refers to para 8 of my petition.
Hmm.
Not one sentence to show.
You come down to page 6,
Page
second
6.
paragraph.
Yes. Yes. Thereafter, considering all the
No. Page 6, second paragraph. of
second
the
paragraph,
affidavit.
that the disciplinary carefully went through the proceeding. He went through the proceeding
Found that.
and found that the inquiry officer conducted the department inquiry in accordance with the existing rules and instruction, and that the procedure laid down in Rule 27 of the CRP Rules 1955 and the charges leveled against the accused have been proved by the inquiry officer.
So you will now argue that this is the inquiry part, not the initiation part.
The initiation is what he had to look into. He should have, the inquiry had to be initiated as laid down in the, because it is a joint departmental inquiry. Had it been an individual inquiry against each of them, no such 27D 1 or 2 will not come in. Since it is a joint departmental inquiry, unless he initiates it in accordance with the rules.
Hmm.
Now, another thing, Lordship will see 5 persons, one single memorandum of charge, one single inquiry, when each, even if we assume that there is some truth in the allegations, each had produced a different certificate. Each verification was separately done. Each may have a different stand. But it is a joint departmental inquiry which is being conducted against them. And therefore, the relevance of Rule 27D 1 and 2 coming.
Take me to the rules once more.
Page 28 in my book.
See.
Starts.
Where
at page
two or
28.
more members.
My lord, yes. When two or more members of the force, including those on deputation to the force, are concerned in any case, the Inspector General or any other authority competent to impose the penalty of dismissal from service on all such members of the force may make an order directing that disciplinary action against all of them may be taken in a common proceeding. Wherein such proceeding, the conduct of a deputation is to be dealt with the consent of the disciplinary authority. That is a note. 2. Such order shall specify the authority which may function as the disciplinary for such a common proceeding, the penalty specified in the table of subrule A above, which such disciplinary authority shall be competent to impose, whether such disciplinary authority shall hold the departmental inquiry himself or may designate any other inquiry officer for that purpose, that the inquiry shall be held in accordance with the provisions of subrule A and subrule C. Just put in one sentence.
Okay.
What
Any
has-
decision to this support? This,
My lord,
any decision on this?
27B as such, I could not, not any challenge to it or otherwise. My lord, what I'm trying to impress before this honorable.
I got it.
No, but what I'm, Lordship will just. give me
But one thing, just
sentence,
clarify
Lordship
one
will take from-
situation. One,
No,
just
Lordship will
clarify
take-
one situation.
Lordship will take only one submission from me before it falls from. What I'm trying to impress before this honorable court is the safeguards given by the law. The law laid down by this honorable court. If not followed by the departmental.
That will
authorities.
be the grave.
So this particular departmental inquiry goes, even in the judgment that I have given to Lordship or other judgments also.
Now, one
It is
clarification.
always the procedure which they have to follow correctly.
One
before they can-
clarification with regard to this 27(1)D.
My lord,
Where two or more forces, members of the force, including those on deputation to the force, are concerned in any case, the Inspector General or any other authority competent to impose the penalty of dismissal from service on all such members of the force may make an order directing that disciplinary action against all of them may be taken up in a common proceeding.
yes.
Now, does this envisage a situation wherein persons of different ranks are involved?
My lord, it does not say so.
It may not say so. It
It
may
does
not
not say so, number one.
Just let's negate that. In that situation, there will be different disciplinary authority.
Yes,
So the highest of them,
yes.
who will have the power to impose a
Will make a
penalty on all, will take a call.
Will-
Here, the commandant was enough.
Yes. But even in that situation,
Hmm.
what a rule may envisage and what a rule lays down in clear words. If there is an order somewhere on record showing that there is to be a joint departmental inquiry and the commandant says that I am the authority.
Yes. Mr. Roy, you have the records with you?
No, Lordship. Records
Why?
are not called for, Lordship.
Okay. Where have you dealt with this submission of this?
Lordship,
That is what I read out.
No, Mr. Majumdar, you find that out, Mr. Roy. You find
I'm
that out.
finding it.
Yes, go ahead, proceed, Mr. Majumdar. Then what happens?
So that is the initiation part.
Fine. Now let's say it is initiated. So if it goes in this, everything goes.
They're very.
Now you come to the charge. Page
Now, my lord, the next sentence that I will read out is. That the, page 15 I am reading, madam. That the
You are
below-
coming to now rule 11,
Now I-
section 11.
Yes. That the below mentioned persons while serving as constable general duty and in their capacity as member of the force described in section 11 of the Central Reserve Police Force have committed an act of misconduct in that day by hiding the souls.
Hmm.
That is one judgment which I have just given. Okay, that you have done. Yes, sir. Lordship of the- High Court. A recent judgment. So that is placed on, before I go to that recent judgment,
Oh, this one.
Lordship, that I don't have a copy of Lordship.
Okay, fine. What happened here?
That has also discussed the impact of section 11(1)
Hmm.
vis-a-vis producing a fake certificate. The same charge. If Lordship will, it was exactly the same charge, which its Honorable Court has discussed by referring to two earlier decisions. Perhaps there are two decisions that I will place before Lordship. Earlier decisions.
2006 2 SSC. Earlier decision.
Yes, Lordship, I am giving one single bench judgment which was earlier delivered and another judgment by the division bench. If Lordship has the Thogendas case, my lord,
Hmm.
their Lordship will find.
Thogendas has been considered here.
Yes. But I'm just reading up Thogendas, what was the fact there? There the fact was of producing a fake tribal certificate, ST status certificate. This Honorable Court held from the decision of the apex court in Ramsar, it appears that in a case of securing appointment on the basis of false information or false certificate, the appropriate action against such person is to be initiated on the provisions of Rule 14 of the CCSCC rule. However, in the instant case, the authorities have taken recourse to powers provided under section 11(1) of the CRPF Act and not on the provisions of 14. Having regard to the aforesaid, I am of the view that this repetition can be disposed of by holding that it would be appropriate for the responding authorities to take recourse to provisions of 14 for taking action against the repetition as is alleged to have secured appointment by furnishing false caste certificate in terms of directions given by the Supreme Court. Accordingly, it is held that recourse to the provisions of section
Okay, fine.
11(1) was
Next.
inappropriate.
What is the division bench?
Division bench judgment, Lordship will find on the second page. The learned single, the third paragraph from the top, Lordship finds. The learned single judge also found that the petitioner was not a member of the force at the time of filling up the application form. Therefore, the action taken against him under section 11(1) of the CRPF Act was not justified. On the above conclusion, the learned single judge allowed the writ petition and set aside the removal order dated 6/9/2001 passed against the petitioner. Last paragraph, in the view of the above, we are not inclined to entertain the present appeal. We are in agreement with the reasoning given by the learned single judge. What had initially fallen from Lordship that this man, on the allegation of having on the allegation of having produced a fake certificate or false certificate, should not be allowed to continue to serve without a inquiry even. I also concede to them. But what I do not concede to is the manner in which they have been dealt with in the present proceeding. Given a fair opportunity, they might have 101 reasons.
You have brought
Hello?
It's an appropriate case. Yes, Mr. Roy, take note of this. It's a coordinate bench judgment, same issue. He is now tying me down.
Lordship,
He is tying me down. This is CRPF again, no?
Same charges, my lord,
Same thing.
same year,
Uh,
2012.
Chandan Rai versus Union of India.
My
Fine.
lord, there's one more, Hanif Ali is there, coordinate bench.
Okay, 2 points taken. Next.
Now, the issue of a presenting officer being not there,
That you did not argue. That is,
from the.
again, the same concept.
Lordship,
This
yes,
is not coming out.
Hello?
yes, your lordship,
This has not come out. Same concept,
same council.
Hanif Ali,
same chamber, I should say.
Hanif Ali,
You are there, Mr. R. Mojumdar. There is no other R.
maybe
Mojumdar.
5 10 minutes at a time.
WPC 105522.
Well,
This is an order of 36.
Hanif Ali perhaps was on.
Let me see.
Lordship, there is one more one. Is not-
Oh, here it's no, it's different.
It's different.
Here the CCS temporary service rules were invoked. That is what he is
Hanif
trying
Ali-
to say. Invoke the CCS rules, not the rule level.
I'm not going scot free. I'm not running away from a department proceeding. I'm running, I'm trying to approach a proper proceeding.
There he asks for an
No, no, no.
inquiry.
This is not. This again supports Chandan Rai. Anyway, fine. Then next,
The next point, my lord, regarding the presenting officer.
presenting officer, forget it.
Lordship will find from whatever records I have produced, they have not produced any records, they have not attached any document to this petition to controvert. But Lordship would find, I have given the order sheets.
I got it.
In the order sheets, which start at page 61, none of the witnesses produce any of the documents. There's nothing in those order sheets to show
Order
that these documents were produced.
But the statements that are there,
The
but the-
statement,
but
that is
No,
why exactly, my lord, I'm
no,
saying.
no, no, what
that the
what
inquiry
is
of-
there is,
It is there. That is what I was
in the
trying to show.
inquiry report,
Lordship will have. Perhaps Lordship is.
31.
31, yes, not only 30,
No, not 31, not 31.
prior to that.
Prior to that.
Lordship will have 29,
28 onwards.
28 onwards. On 24/5/2012, prosecution witness so-and-so ministerial was, witness number 3
You
was.
come to the
examined,
last lines, 2 lines.
And after recording the
No, no, you
statement.
come
all
to the
evidence-
last line. Page 28, last line. On 31/5, over and above the listed the statement of so and
Let us now pause
who
here
had
for,
gone.
let us pause here for a moment, madam. Let us pause here for a moment.
Hmm.
Lordship will come to the list of witnesses, which Lordship will find at page 22, the original. I'm sorry.
15.
I'm on the Hindi part, my lord. Page 25, Lordship will have. Who were the witnesses given by the prosecution? By the authorities? Adjutant, Mukhya Lipik and Sthapna Lipik. Who proposed this fourth witness to come?
You read number 4.
मामले के संबंधित अन्य कोई गवाह जिसे जांच अधिकारी जरूरी समझते हैं. My lord, now the CRPF Act and Rule says that whatever is not provided for in the CRPF Act and Rules, we go to the CCS. In the CCS, the method for calling in a new witness is on a proposal made by one of the parties, and then the inquiry officer decides whether he is necessary for the investigation or not. So
Okay.
before he takes a decision that this man is necessary to be called in, who proposed? Who asked for a witness? If he has thought of his own that I will get this man also, will try to go into the root of the matter, then he's not acting as a person who's an inquiry officer.
Unbiased.
He's not unbiased.
Okay. Next point.
He has the authority to go into it, but it has to be done in a manner which is understood in law.
Okay, fine. Next.
Now, the order sheets will show that no production of documents is recorded in any of the order sheets. So who produced the order sheets, who produced the documents? And now another one missing. Lordship will kindly have Rule 27, how it is to be done. Rule 27, Lordship will have Rule 27C, because my lord, when a joint departmental inquiry is held, one of the things that the convening authority has to do is say that Rule 27C will be complied with. 27C, Lordship will find at page 27. C3.
C3. When the documents are relied in support of the charge, they shall be put in evidence as exhibits. And the accused shall, before he is called up, be allowed to inspect such exhibits.
Now, my lord, when the documents are supposed to be relied upon, the statement that reliance has to come from the disciplinary authority through the presenting officer.
Hmm.
And therefore, the absence of a presenting officer is what I'm impressing on this one.
Okay. Then next one. Taken.
Therefore,
Taken.
in this view of the matter, if when this honorable court has held that it will not be section 11(1), cannot be proceeding under section 11(1), when the very initiation of the disciplinary proceeding under 27D was not in accordance with law, it did not.
Fine, I got it, Mr. Muzumdar. Next.
The presenting officer having not performed his duty correctly.
You
My
give me
humble
the
submission
next
is-
point.
No, my humble, even if you are restricted to here also,
Okay.
even in that case, this particular disciplinary proceeding has to be. The
You are saying in terms of that
Chandan Rai's
Rai's
case,
case,
Chandan Rai's
it
case
has to go back and are proceeding under the CCS.
Even in that case, my lord, the magnitude of the accusation has been taken into account. That this is a grave charge. Lordship will find, somewhere towards the end, my lord. It has been observed by this honorable court that the charge is grave. Therefore, it requires perhaps a relook by the department. But it has to be done in the manner which is,
No appeal has been filed here.
as of now, no. And even if, my lord, even if in the case of Chandan Rai, they do prefer an appeal, the earlier division bench judgment saying 11(1) will not apply, and the presenting officer part, coupled with, my lord, the
Yes, Mr. Owen.
Lordship, regarding Chandan Rai, Lordship, no, say that he is in the process of filing an appeal to that.
Today you are not filed. So
Not
that is
yet,
the law.
not yet. So regarding Lordship, 11(1), Lordship, we have not done because Lordship, we have given them an opportunity to heard. So we have taken it 27(1)D, we have followed Lordship.
27?
27. Department. We have followed the rule 27, Lordship, giving them an opportunity to hear, Lordship. But Lordship, I will see the.
No, which part of 27 did you follow? He says D1, when there are more than one, why that was not applied?
This is the procedure, Lordship. We have followed this, Lordship.
Not on that. 27 D1. That there has to be a common proceeding against all.
Yes.
There has to be an order.
Lordship.
Is there an order?
Lordship, that memorandum is an
Memorandum is not the order.
Because
There has to be an order.
this is, this memorandum is the order document, whereby they follow this rule.
That means my question to Mr. Majumdar,
Lordship,
that all being in the same rank
Lordship,
and the commandant being the disciplinary authority in all,
Lord,
right? So that order,
Lordship,
if it is not even passed, will not be prejudicial.
Lordship,
Would that be your stand?
yes.
Then support it.
Lordship, because this
Because
is
till I
commanded,
write an order, by this view will not be final.
Lordship,
So you got to finalize that view. I'm giving you a handle.
Lordship,
Because statute says pass an order.
Lordship,
My view that when there are more than one ranks involved, there may be a situation,
Lordship,
then this may be required.
required.
But if there is only same
Same rank, Lordship,
rank, this may not be required. But Mr. Majumdar will be very emphatic in that.
Lordship.
Okay. Then the Chandan right, 11 one. And that too, again, there is a division bench judgment also.
Lordship, regarding that,
That you cannot have 11-1. You will have to have it under,
CCS,
because he had not become a member of the
Member
force
of-
when he had done that act.
Lordship,
But there are judgments.
but Lordship, just to give them an opportunity to hear them for following the natural justice, Lordship, we have done,
Now confirm one more thing. Show me from record
Lordship,
that the letters of the SEBA, where were it exhibited in the inquiry?
Lordship,
Who had exhibited the letters
Lordship,
from SEBA received saying that those certificates are forged? Wait, where is that exhibit here? From which the conclusion was drawn
Lordship.
that the fake certificates have come. Where is that letter? You come to your charge sheet.
That to report the recognize.
Come to page 15. Fifth line. On the basis of fake educational certificate.
Lordship,
Page 15, right?
Lordship, page 17, Lordship. List of documents by the allegation against so and so, so and so, so and so. The details of certificate produced by each of the persons are as follows. They given this now.
Okay, okay, this is the one I was. SEBA Tech Very 195, 172, 27/4/2011, 26/2011, and 13/1/2012. These are the three documents by which you conclude
Look.
where we exhibited in the end. Who exhibited in the end?
ये exhibit कौन किया कौन सा list
Not the certificates. I want the
letters.
reports. Mr. Majumdar, relax.
exhibit कौन किया
Ganesha Rai is one of the petitioners, I guess.
Yes, madam. We have five petitions.
Just show me that it was produced by someone.
Lordship, it was given along with the memo of charges, Lordship.
No, you'll have to prove it in the inquiry.
That's
It has to be produced in the inquiry.
Lordship comes to page 38. The translation may not be only correct for Lordship will have page 38. The Hindi version. जांच किए गए अभियोजन पक्ष Lordship means on page 38.
I am reading that in the English version.
My lord, we will have the Hindi version.
Wait. Difficult.
No,
जांच
I-
अधिकारी की
read it out.
report.
I'll read it out. Lordship has the bold part.
Page 38. हाँ.
Page 38, I'll read it out. जांच किए गए अभियोजन पक्ष is in the somewhere in the middle, below the second paragraph in bold. Then Lordship will have दिनांक 24/5/2012 को सभी आरोपित कार्मिक. Then the names come from the 1, 2, 3, 4th line from the top, 5th line from the top. I am reading. Pal संख्या 0650101122.
Where did you get it?
5th line from the that
Second paragraph.
third paragraph.
Third paragraph.
From the top third paragraph, I am reading.
Hmm.
दिनांक 24/5/2012 Lordship finds the date.
Page 38.
Page 38.
हाँ, दिनांक 24/5.
24/5/2012 को सभी आरोपित कार्मिक. This is the first line. Then 1, 2, 3, 4. 4 lines Lordship will leave the 5th line starting. I am coming. Pal
06.
संख्या 0650101122 हवलदार मंत्रालय सूरजमल कोली
Hmm.
उपबंध 4 के अनुसार अभियोजन पक्ष का बयान दर्ज किया गया तथा बयान के पक्ष में दस्तावेज संख्या 1 से 8 प्रस्तुत किए.
So that is there.
So this paragraph says
गवाह
that
के बयान कलमदम करने के उपरांत सभी आरोपी कर्मी को गवाह से
प्रश्न जिला प्रति परीक्षा क्रॉस एग्जामिन करने का उचित अवसर प्रदान किया गया परंतु सभी आरोपी को मना किया. Now Lordship will kindly have. So this is the first witness who
So
says
he is
1 to 8
witness
प्रस्तुत
number
किया.
1.
He is witness number 3. As per the list, he is witness number 3. As per the list of witnesses given with the memorandum of charge. Now again, Lordship will have in the immediately.
So it was exhibited.
No, that is what I'm trying to show. So he brings it. Then Lordship will have the next paragraph where witness number 2 is being stated on the immediately next paragraph.
Hmm.
It is witness number 2. There Lordship will find third line from the bottom of the paragraph. बयान के पक्ष में दस्तावेज संख्या 1 से 3, 1 से 13 प्रस्तुत किए. He again exhibits. Now both the officers cannot have the same documents with them all the time. Then Lordship will come to the third paragraph.
We can be
He
so
also-
technical.
He also is shown to have produced the
13. 1 to 13.
1 to 13 again. Now Lordship 1 to 13. List of documents Lordship will find has only 1 to 8. Now one of my arguments would be when I had notice of 1 to 8, 9 to 13 without notice to me. Calling in the fourth witness without notice to me. That is where the biasness comes in. Production of documents without notice to me. And it does not say whether the presenting officer produced them or these people produced. them.
Okay. Yes, Mr. Roy.
Lordship, from the record, it says Lordship, Nagesh Kumar has produced this exhibits.
That's the record.
Yes, sir.
Oh, show me. Mr. Roy,
Lordship,
you will have to mark the relevant portions for me.
Lordship.
Where is the exhibits mark here? Ah. And we got 8. Yeah. Okay. Ah. You mark it. Give me an index.
Lordship.
Yes. Anything more?
That's the gravity of the offense, Lordship, it has to be. One more thing, they have not even made the Sevaya party here, otherwise it can.
Naturally. Why will he dig his own grave?
I'm believing there.
Why will he dig his own grave?
Lordship, that
Huh?
on the
My
non-joiner
first
of
question to him was that only. Forget everything. He's
non-joiner
your
of
certificate. And we know Mr. Majumdar, what he is. He will never give a straight answer. But he has made out a case somehow.
Lordship.
So, when can you give me these records? Today?
Today, Lordship, I will just
Mark it, make an index.
Lordship.
And Mr. Majumdar,
Madam.
give me a short write-up. The points you have taken, 1, 2, 3, 4, and with the papers. Exhibits made.
That I was not aware of. I was told that no documents were stood there.
That's what, because I found
That's
that,
what I had pointed out. to
because
Lordship
what I found was the documents were being exhibited by the concerned man, and it was done by a clerk, not by the extra people. Anyway,
And therefore, I pointed out from the original version that these people might have got in the documents. The translation may not be correct.
so you give me a small write-up by tomorrow. Hmm? And this, and you also give me a small write-up.
Lordship.
Tomorrow we'll do. Your stand.
Lordship.
Because the points you have taken, you know,
Yes.
27, 11, then presenting officer.
No.
Presenting officer, okay, if the other two is right, presenting officer, we can ignore. But that too you will have to deal with.
Lordship.
And his third point, that there is, documents were not exhibited, that I don't think so is correct.
Lordship.
That he does not know the records, maybe.
In case Lordship holds that the inquiry was not done in a proper procedure, though.
That thing goes.
No,
I'll not even enter into it. But if I hold that subject to reading of the judgments again, that 27 and 11 complied with. Then, because I have taken a view, let me just
27D1 may not be.
may not be required because at different stages, it's not there. And then I'll go back to justify my order to the gravity of the judge. If I hold that way. But if I follow the other judgment that they are applicable to the facts in this case, then maybe I'll have to follow that.
In Ramsaran's case, my lord, which was referred to by Thogendas also and the other one also.
Division bench.
No, but the Ramsaran was Supreme Court case, which is.
2006.
But there, the Supreme Court took into consideration the fact that this kind of thing should not be forgiven. Even my personal view is, you have deprived someone, if you have done that, you have deprived someone of a job who was eligible at that point of time, it should not be forgiven. My duty as a lawyer, my lord, here is to see
You have
that the
placed-
law should be, they should do it in the proper procedure. That is what I stand here for. And therefore, my lord, judgments that have come from
give us the liberty to.
that was given in Chandan Rai, which they want to.
To move against him.
Lodge.
Let me think.
Lodge.
Because I'm not
Because
yet.
the genuineness, main genesis, my lord, is the genuineness of the document.
Let me examine. If I come to the conclusion that 27(1) is 27(1)D is called for, then I'll follow the judgment. Otherwise, with this sort of allegations, not a fit person. And Mr. Majumdar, one more thing. If we hold that you will be entitled to a proceeding under the CCSCCL,
Yes.
we will not direct for your reinstatement. We will only direct for your reinstatement for that proceedings, not beyond that.
Lordship will see the, Lordship will kindly have this. But I have to leave it to Lordship, but if what.
I
As
will
per
say
my
this
very-
proceeding is interfered with to the extent because of this technicality, but considering the gravity of the offense, he is not reinstated, but he is only technically
moment
reinstated for the purpose of
The
the
moment,
proceedings.
with the moment Lordship says the gravity of the offense,
Then it might
I
go
become,
against him.
I become an offender.
I'll not
and-
say that, but
and
I'll say,
If Lordship says the gravity of the allegation.
okay,
then
fine. I'll
tomorrow
not
any
even go into
allegation may
that.
come.
I'll not even go into that. Because Mr. Roy is making a submission that he be given an opportunity under the CCS.
That was given in Thagendas also.
Fine. But even if I do that, I'll not allow you to receive salaries
But this,
till this thing is.
but once I'm reinstated, even for that purpose, from the day I'm reinstated,
I'll hold.
I
I will
remain under their service.
You go on appeal, I'll hold.
Lordship will kindly consider one factor. Now I'm home.
I'll
I
only
keep my family.
reinstate you.
Lordship will-
It's not
Lordship will consider one-
uncommon. It's not uncommon for reinstatement for the purpose of an inquiry.
The Supreme Court says that if I remain, that for that period, if it is only for the purpose of an inquiry, then I am deemed to be under suspension. And then I receive my substance allowance. Otherwise, how does? my
We'll
family
provide
and
for
I
you
suffer?
subsistence allowance,
Huh?
naturally. We'll have to provide something for
He
you.
has to come, my lord. Otherwise, I will be under
But-
their office, their.
But
their
this
headquarters.
order would be subject to the further proceedings.
Yes, naturally has to be. They have to undergo a proceeding.
Forgery. we
The
cannot.
liberty. to
You
proceed-
have a case on technicalities.
What?
Different.
What I would like to submit for this honorable court is, Lordship will not take a view that this is a man who deserves to be punished. I am just putting him aside inside the technicality and therefore nothing.
I'll not do that.
Lordship will not have that view. Lordship will
is-
have a view.
This is the background of the order. only.
Lordship.
This is the background of the order.
Lordship may perhaps have a view that this requires an inquiry. The liberty to inquire will be with them. And in what manner they do the inquiry will be, they will be at liberty to decide everything. That is what the FRSR also says, my lord. That
Give
once
me
there
your
is a reinstatement,
respective written arguments by tomorrow.
FRSR says, my lord, on a reinstatement, even the Supreme Court says, if on a reinstatement, it is for them to decide how to.
Do you want orders wherein Supreme Court has said that a technical reinstatement can also be permissible for that inquiry purpose?
Yes, but for that matter, after the reinstatement, he survives.
Let me see what I can do.
My lord.
By tomorrow,
Lodge.
records plus
Lodge.
a write-up. You also ask if you give a write-up.
Lordship will hear the matter again. or-
No, no, I've closed it.
Put it,
All the file. Closed.
Obligation.
But you'll get the orders next week. only.
No problem.
I asked because I've been playing some. See, this was. Good morning.
In case, my lord, some clarification is required, I will not be here tomorrow.
No clarification. You give me a write-up, that's all. Made up. Only thing, which way to go now. That's only thing I did. 13, 14, 15, 16, 17. कुछ नहीं लिखा. ठीक है ना, सब यह कोई नहीं. This was great.
Item 18.
List this matter before any other bench without me. I can't take up this matter. Page 36.
Okay.
I had it here.
Yes, yes.
Without me, write my name. Next.
Okay.
Item 20.
19 to dispose of infractions. Again, same order, not by me. I had appeared for one of the private respondents. Yesterday
Deeply
was
obliged.
shifting, I saw it.
No escape, lordship.
21.
Item 21.
May I please your lordship? Lordship, we have instructed to petitioner for withdrawing matter.
Withdraw.
Also,
They want to withdraw.
In fact, he has been regularized in another.
Another school. That's what I was. First question would have been that your name figuring in Kujida. His
Yes,
name figures in Kujida.
Yes.
Then how can he claim for, because these are merit lists, how can he claim for the
Jajuri.
Jajuri? Anyway, they don't want it.
Obliged.
On Miss
M. Bora.
Miss M. Bora, non counsel for the petitioner. You're not the counsel for the petitioner. You're appearing for Miss D. Borga.
D. Borgo.
Appearing for Miss D. Borga. D. Borga. On instruction, submit that the petitioner desires not to press this matter any further. Accordingly, the petition stands dismissed as withdrawn. Interim orders, if any, shall stand.
Will that be appeared, my lord? That may be recorded.
Mr. N.K. Chaudhary.
Respondent number 3.
Senior stand, N.K. Chaudhary, Mr. M.K. Chaudhary, senior advocate. Hearing for the respondent number 3. Assisted by Mr. M. Sharma and Mr. U. Sharma for respondents. 1 and 2.
Obliged.
Obliged.
Not up.
Item 47. Top of the list matter.
Oh, but I don't miss serially. 47 phones. BJP, actually, serially. Boston guitar. 22.
For motion, item 22.
My senior leg at 2, lordship.
Just who is your senior?
M. Khan, lordship.
Where is the inquiry report here? The disciplinary proceeding, you have the inquiry report. What is this manner you are doing it, Mr. Sharma? He is the director, the inquiry officer. Anyway, let Mr. Khan come.
Appeal is pending almost.
Yeah, fine, let Mr. Khan. Call him. 2 o'clock. Next.
Ice.
Oh, Mr. Khan. Yes.
Silence and order, that is page 49.
I know that. There was a proceeding against you.
Well,
Where is that inquiry report?
inquiry report was not furnished to me.
Not furnished.
Earlier I approached,
Then last time these pleas were not taken.
Well-
You only said that no hearing was given to you.
no hearing. No.
And accordingly, the hearing is given. What
Hearing
more
was
is
given.
required?
Earlier, that still was taken, because it was not,
No. The order.
my lord. In order, that is not reflected.
Then we can only go by the order. Para 4.
And even that lordship, the punishment that is awarded to increment with cumulative effect, that is not prescribed under the law. That is beyond the,
To increment with cumulative effect not prescribed.
my lord.
Why not prescribed? Withholding of increments. Penalty is there.
Withholding of increment.
That is either cumulative or non-cumulative. That is what the inquiry of, that's for the department.
My lord, there is a judgment in that regard.
Hmm.
That judgment is not available at present.
Hmm.
2019 4 GLR 118.
2019 4 GLR.
118,
What does it say?
that so far the cumulative effect is concerned, that is not prescribed under law. That,
We will clarify that.
let at this statement a notice may issue us.
No, you have preferred an appeal against this.
Yes,
Where is that?
that is last
7-9.
para
Okay.
lordship page 50.
Why have you not considered this appeal?
That appeal has not been considered this day. This was received on 7/9/23.
I think you come back after this appeal is disposed of. Because you have taken the plea. Otherwise, this will be a bar for you. Earlier order. Hearing is given.
Hearing even.
Then.
And so far the prescription of the punishment is concerned, lordship, that is beyond the purview.
The petitioner has instituted the present proceedings being aggrieved by an order dated 26/5/2017, by which a penalty of withholding of 2 increments with cumulative effect was imposed upon him. The period of suspension of the petitioner was directed to be not treated as on duty for all purposes. So, in pursuance to an order dated 8/6/2022 passed by this court in WPC number 904/2018, the Director of Higher Education, Secondary Education Assam, Director Secondary Education Assam, had afforded an opportunity of hearing to the petitioner. And on 8/12/2022, and thereafter, while his order dated 17/6/2023, on consideration of the matter, had retained the earlier penalty, but held that the suspension period of the petitioner shall be counted as on duty for all purpose. The petitioner, being aggrieved, had instituted an appeal under Rule 15 of the Assam Services (Discipline and Appeal Rules 1964) before the Secretary, Government of Assam, Department of School Education, on 7/9/2023. आगे तो date नहीं दिया ना, एक 2 बार होना चाहिए. 7/9/2023. Full stop. The said appeal is presently pending disposal. In view of the above position, without opining anything on the merits of the matter, opining anything on the matter, the writ petition, the Secretary, Government of Assam, Department of School Education, is directed to take on record the appeal of the petitioner and to dispose of the same within a period of 2 months from the date of receipt of a certified copy of this order. Full stop. The appellate authority shall provide an opportunity of hearing to the petitioner, and thereafter, basing on the contentions raised in the appeal as well as the materials brought on record in the hearing, pass a speaking order dealing with all such contentions that the petitioner has so raised in the appeal. Full stop. The above exercise be completed within a period of 2 months from the date of receipt of a certified copy of this order. 3 months, 3 months. The petitioner for taking the matter forward shall submit a certified copy of this order before the Secretary, Government of Assam, Department of School, with the above observations and directions of the petition stands. This disposed of.
Obliged.
You will have to come out of that.
My lord.
This is the way.
Item number 8.
Yes. Oh, no. It's that on.
Post koro.
Yes.
Lordship, I got the information, Lordship. The petitioner expired on 5th January, Lordship, 2024, Lordship. I'm sorry for that, Lordship.
Now what to do?
Lordship, I may allow to liberty to file it as a legal head shall be filed, Lordship, regarding, Lordship, the pending family pension.
But it will be a futile exercise because there is nothing here. I've gone through it.
Lordship, whatever
Subject
I
to you,
is a,
because that promotion of 96
yes, Lordship.
was not given to you because of the department proceeding. Department proceedings culminated in a penalty. That penalty still holds the fee.
Lordship, in as much area, order dated 29/8/1998, Lordship. Sorry, 2009, Lordship. 18/8/2009, Lordship. Page 50, Lordship. Defined, Lordship. One aspect.
Page.
Page 50, Lordship.
Huh?
So opportunity has been given, Lordship.
Page
Page 50, Lordship.
50.
50, Lordship. And the WBC long 4331/2008, Lordship.
4331 2008, my Lord Justice C.R. Sharma's order.
Yes, Lordship.
And therein only the penalty of 13(6) was interfered with. The earlier penalty was not interfered.
And given, Lordship.
And there are statements here. If you can come to the order, which starts at page 55.
Yes, Lordship.
Can come to page 59, second paragraph.
Yes, Lordship.
Read that.
59 says, Lordship, the opportunity.
Second paragraph. Having heard the learned counsel, page 59.
Yes, Lordship.
Hmm.
Or the judicial review.
Have you got it, Mr.
Yes,
Gupta?
yes, I got it.
Having heard the learned counsel on the carousel, so and so it is found that the order dated 1/8/2005, passed by the disciplinary authority imposing punishment of so and so, recording 2 black marks, was not challenged by the petitioner before the appropriate, thus accepted the said punishment. Now, once you have accepted that said punishment, your promotion cannot be given from that 96.
Promotion 98, Lordship.
98, you cannot be given.
And Lordship, whatever, Lordship, so one aspect, Lordship, based on, Lordship, the PS 27, the DP proceeding has a quashed by the Honorable.
No, but thereafter it was again retaken and then a penalty of stoppage of one
Yes,
increment. was
but
given.
initially it's that is the VP lordship. But
Initial maybe, but that liberty was given to them to
Yes,
proceed. They proceeded. And the final penalty is 182,005. Enhanced penalty gone. That I understand.
now the petitioner expert lordship on the 5th January.
No, you will bring the family on record. I understand that, but
Yes,
now you will have to bring that family on record. But what benefit will they get?
lordship, as per the direction of the court lordship, the representation is submit lordship for the opportunity lordship. The representation lordship page 6 lordship. The petition is submitted on 24/8/2009 lordship. Page lordship, page 60 lordship, 60 lordship.
Okay.
Also have lordship, the two judgment lordship, Jawar Mazalul 1979 lordship. So their opportunity to be granted lordship. The piece
What opportunity you want?
to file a or in regarding this hearing the
Your this amendment application has not been allowed. Was it allowed?
yes, lordship, allowed lordship.
Allowed. So now you come to the prayer
Lordship, page 60 lordship. that is
16,
60 lordship.
60 or 16.
60 lordship.
Read.
Lordship, first paragraph lordship. The most humbly, thus respectfully, I beg to state that the Honorable High Court, its
No, I'm not on that. Writ petition prayer.
yes, page 16 lordship.
Hmm.
Where is lordship? Under the aforesaid facts and circumstances, it is therefore paid.
You forget it. Come to the bottom part.
Yes,
Benefits to the applicant to the post of so-and-so with effect from the date when his junior was promoted with all financial benefit in terms of the order dated so-and-so, passed in so-and-so, and order dated
Dated.
18/8/2009.
yes,
Now you come to 18/8/2009.
yes.
That is at page
Page
54,
50 lordship, yes.
the finding that I showed you. That is the finding. Page 59.
Yes, lordship. Yes.
Then
He admitted.
so let us give this a quietus.
Lordship, the last paragraph, lordship, here mentioned lordship, in as much edit in order dated 18/8/2009 lordship. Last
paragraph.
However, the
Okay.
respondent authority shall have liberty to take up the review matter de novo
Dino,
if the advice after giving due opportunity to the petitioner as per rules, lordship. As per rules, opportunity. So there.
what is the meaning of this, Mr. Das? That means that reversion which was done, they can do it again by giving you a notice. That is the meaning. How will it help you?
Yes, lordship. And the Supreme Court had lordship to judgment lordship, the 1979 lordship. So the opportunity ought to be granted to the agreed person lordship. So on
What opportunity I should grant to tell me?
regarding this DP lordship.
DP is over.
And lordship, the page 27, initially the was these are disciplinary proceedings.
Was then again taken up.
Again taken on.
Then?
And lordship, the one opportunity ought to be granted to the legal heads lordship in regarding
To come before this court.
if proceeding lordship. to proceed.
I don't find anything in.
Yes, the expert person. Impedance for lordship.
Yes, Mr. Kaushik. If a petitioner dies in the meantime, can this court take up this matter? Because I find nothing here.
Hello.
Can I dispose of the case? I'll have to have the substitute. You make the substitution.
Yes, lordship.
Mr. Asidas, the counsel for the petitioner, has submitted that the petitioner in the present proceedings had expired on 5/1.
Fifth one, lordship.
5/1/2020. Accordingly, he prays for an opportunity to bring on record the legal heirs. So, The prayer is accepted. The petitioner is permitted to file the requisite application or bringing on record the legal heirs by 29/1/2024. So list this matter again on 1/3/2022, 24 with the said application. Interlocutor.
That's all.
Right. 24. 25/1/24, Mr. Das.
Fifth, Lordship, fifth,
Fifth.
fifth or not, yes, Lordship.
The 5th January.
January, Lordship. Indeed.
24.
Pass on.
For motion, item 23.
Yes, Mr. Mahmood.
My lord, this is the case where the SMC has been constituted in violation of the rules of 13. Here the guardians of the school are 26. But what appears as has been learned reliably 38. So that is the wrong committed by the management. And main allegation is against the headmaster.
I got it.
Headmaster did not want that a fair committee should be constituted as per rules. Because he has some scams of the last few years. And if the SMC is constituted by.
Has the SMC
So
taken
that is
over?
there.
The new committee?
So far rules 13
No,
is
no, no,
concerned. by
Mr. Mahmood, has the SMC taken over? Because these things happened in.
No, that is not
October.
yet approved. I have mentioned categorically, I have mentioned.
Hmm.
That is not approved and we have filed petition.
Where?
That petition is not yet
17.
disposed of.
You have filed a petition before the block elementary education.
Yes, that is done. Page 10, para 5 BBC.
Page 10, para 5.
Yes. And when there are mandatory provisions and rules of that should be followed, majority of the guardian signatures were also not taken. We demanded the proceeding book that has been denied. So all these things create our doubts more stronger. So that is there, but failed because of non-cooperation of respondent number 7, 8, and 9. 9 is the headmaster.
Who is the appropriate authority now to examine this matter?
This DO will be there.
DO.
And departmental representative should be.
That's what, if you have said that departmental
Not
representative was also.
Were not present, SI or BO or DO, either of these three persons. But none were present here.
Now, who is operating the school management committee?
The managers.
Who is doing it? Who is
Now
discharging the functions?
At present, the earlier committee has been perhaps maintaining, but the new committee is not yet approved. So our prayer is this, as there is strong violation of Rule 3 of the Assam right of children to free and compulsory education 2011, where the departmental representatives were not present and majority of the guardian signatures was not taken in the proceeding book and nothing was provided to us even on asking. So all this create serious doubts that in the next SMC headmaster will be rather more benefited at the cost of the school's interest. So Lordship may kindly dispose of the matter, asking the DO to examine.
I'll ask the director to look into it. And till that time, let the DO take charge of the school.
Yes.
The petitioners who claim to be parents of the guardians of students studying in 1293 number Sunaichera LP School have instituted the present proceedings, raising a grievance with regard to the process undertaken for constitution of the school managing committee of the said school. It is the allegation of the petition that the process that was undertaken for constitution of the said school managing committee was in clear violation of the provisions in this connection, provisions available in this connection under Rule 13, bracketed 3, bracketed Roman 3, small, of the Assam Right of Entering to Free and Compulsory Education Rules 2011. It is the further contention of the petitioner that the petitioners that the said school management committee, which was purportedly formed in a meeting held on 30/11/2023, is yet to be approved by the departmental authorities. Accordingly, without opining anything on the merits of the contentions raised by the petitioner, the petitioners are now required to submit a detailed representation before the Director of Elementary Education Assam, highlighting the illegalities that exist with regard to the constitution of the school management committee for the 1293 number Sunai Sera LP School. Also, the director, on receipt of such representation, shall cause an inquiry made into the allegations as leveled by the petitioner. And after affording an opportunity of hearing to the petitioners, would pass a reasoned order, taking into account each and every allegation brought on record by the petitioners. Also, the said exercise be completed within a period of 2 months from the date of receipt of a certified copy of this order, along with a receipt of a representation as a copy of the representation as required to be submitted by the petitioners, along with a certified copy of this order. Also, pending consideration of the said representation by the petitioners, the activities of the school managing committee of 1293 number Sunai Chera LP School shall be managed by the district elementary education officer.
Karimganj.
Karimganj. Also, with the above observations and directions, the petition stands disposed of.
Item 24.
Yes. What is your instructions?
Lordship will give me 1 week time and I can place the compliance.
Mr. Kaushik submits, Mr. B. Kaushik from the Standing Council Secondary Education Department submits that the process towards compliance of the directions passed by the court, while order dated 14/6/2023 in WPC number 90/2022 is under process, and the same would be concluded within a week's time. Also, accordingly, list this matter again on 30/1/2024, on which date Mr. Kaushik shall place on record the compliance report. Place on record the compliance report. Well,
For admission, item 25.
Your Lordship, the matter may kindly be adjourned for the day as my senior is medical emergency.
who is your senior?
Mr. Jed Hamad. Mr. J. Hamad. Jed Hamad.
My lord, he is represented the private respondents. Today morning, he informed me that his child is severely ill.
Okay.
That's
No, enough.
taken up on some other.
On the prayer made on behalf of Mr. Z. Hamad, Learned Council appearing for respondent number, is appearing for respondent number,
Yes, 6. Lot 5 and 6, my lord.
respondents number 5 and 6. This matter stands adjourned for 2 weeks. Also, list this matter again on 7/1/2025.
7-2.
7/1. Fine.
Highly obliged.
7/2. 7/2.
7-2.
Sorry.
Yes. Highly obliged.
Obliged.
Item 26.
Yes, Mr. Ram.
My lord, the petitioner was selected for the appointment of the lecturer post lordship in the Majuli College as for Assamese language. After due advertisement and after facing the interview board, the petitioner was selected. Lord. And the lordship, the vacancy was against a sanctioned post. That will be clear on the perusal of the annexure. Lordship, may please to come to page 17, Lordship, annexure 1. This is the advertisement given by the college. Applications along with testimonials or marksheet from HLC onwards are invited from the candidates having UGC norms for the following post of lecturer with a cross postal order of so in favor of Principal Majuli College, Kamlabari, within 10 days from the date of publication of the Assamese one post sanction. This is as per the lordship, I submitted my application, and after the interview, lordship, the petitioner was appointed, lordship. That, and the petitioner, lordship, may come to page 28. This is the election committee report, lordship, regarding which the present petitioner at the bottom, lordship, he stood first in the interview. Karthik Nath is the petitioner, lordship. Then, lordship, may come to page 29, annexure 4. This is the appointment letter given by the Majuli College, lordship, dated 23rd/11/2003. This is the and next is the joining report by the petitioner. He joined on the same day, lordship, 23rd/11/2003, lordship. And since then, lordship, he has been.
Page 31 is the request for your approval.
Yes, lordship. At that time,
When you
lordship,
approach
the
this-
college was not provincialized. It was in granted deficit
grant.
in grant, lordship. So,
When
lordship,
you approach this court. Order 68.
This is the order in the earlier writ petition filed by the petitioner, lordship. 68. By the order is by the Honorable Justice Sri Ujjwal Bhuye.
Okay. Yes, Mr. What's your submission?
Lordship, may I please to come page 71. The
No, I've read it. I've read it. You can proceed.
Lordship, by this judgment, lordship, the director of higher education was considered the case of the petitioner because in the meantime he has completed his MP. But by the improved order, Lordship, the exchange order has been passed, that your Lordship will come to annexure 15 page 73.
I've seen it.
There is nothing regarding the MPhil Lordship.
The only thing that they have said is that you did not have the UGC norms when you were appointed.
Yes. At that time, Lordship, it was relaxed, and if anybody MPhil has done, that was okay, Lordship. But the Honorable Court in the earlier round of litigation had clearly mentioned that the.
So earlier round of litigation, 17/7/24, 2004 OM gone.
Gone.
The only thing now available to you is whether your case could be considered for regularization. That much only. What is your submission on that?
My submission is that Lordship, when I have completed my MPhil Lordship, and even if that has not been considered by the improved order Lords, nothing, there is no whisper.
You had completed your MPhil after your appointment.
After. I appeared in the MPhil examination in 2010 and the certificate was issued in 2012 Lords. The circular of.
What was the norms, Mr. Chomua, when this?
MPhil has never been a required qualification.
No, forget it. What was the norms when this 23/11/2003 appointment was issued?
Well, at 55%, good academic records, neat and slow.
I had secured 57%.
No, that is not quarrel on that. He does not, he did not have neat and slow.
Okay.
Neat or slow.
Yes, Mr. Gogoi. It is your ball now. Mr. Somo has done his part. Yes, why have you not regularized this man?
Lordships is not within the ambit of regularization, Lordship.
Forget that 17/7/2004, that is gone.
Lordship.
That earlier direction of this court,
Lordship.
page 71, second paragraph, last line.
Lordship. Lordship.
So the only question is whether he being appointed
Lordship.
against the sanction post.
Lordship.
At that point of time, maybe he did not have, but he came through a process of
Lordship.
regularization, process of interview,
Lordship.
selection, and all.
Lordship.
Whether his case can be considered.
He is not appointed against the sanction post, Lordship.
No, there is a finding in
Lordship.
page 71.
No. Yes, sir.
You come to second paragraph,
Lordship.
1, 2, 3,
In
4,
so
5,
far as the
6,
proposal
7,
of
8,
governing
9,
body
10th line.
regulation service. Lordship.
Though the petitioner was appointed on 23/11/2003, such appointment was against the sanction.
My lord may kindly come to the death appointment letter. Kindly come to the appointment letter.
There it says no salary.
No, Lordship. So Lordship may
29.
kindly come to page 29, Lordship.
I'm having it.
It's purely on temporary basis, Lordship.
Every initial appointment is
No,
on.
Lordship, it is not against that recommendation also. Lordship.
Mr. Roy, where was the advertisement?
Lordship.
Advertisement Lordship. Page.
Page 1, page 18. 17 is the type copy.
You come to page 17,
Advertisement
SMS.
page Lordship
page
70.
17. Assam is one post sanction.
Lordship.
So that finding here in the judgment has attained finality.
Lordship, it is a sanction post or advertised, Lordship. That particular selection has not attained finality. We have not considered his
That's
case,
what
Lordship.
the argument is.
It is not considered his case, Lordship. We have rejected his case on the ground
Where
that,
is that order of your rejection?
Lordship, the rejection order is, Lordship, on in page, Lordship, as per Honorable Court's direction, Lordship.
Annexure 15.
No, that impugned order.
Lordship, page 68, Lordship.
No, one is at page 73.
No. Page 68.
Now come to the last 1, 2, 3, 4th paragraph from bottom. As on today,
Lordship.
There is no post.
Lordship.
what is that? If there was a post, would his services
No,
be
Lordship,
regularized?
cannot be, Lordship.
Why do you write all this?
We cannot override the rules and regulation, Lordship.
Yes.
We cannot.
So,
Lordship.
Lordship, the OM of issued by the government itself provides Lordship.
Which
Annexure
OM?
9 Lordship, generally a person.
page.
Page Lordship and Annexure 9 Lordship, page.
But you are not working against a non-sanctioned post, Mr. Roy.
No, that was the earlier lecturer lordship, he retired. That was a sanctioned post. In lieu of that, the advertisement was given lord.
And you are in a sanctioned post.
In the advertisement itself, lordship, it is mentioned in bracket, sanction. Sanction. Lordship may come to page 34. Page 34, Lordship. This is the OM issued by the government, Lordship. Your Lordship may come to clause number 4. My learner friend is saying that it was a non-sanction, even if that will apply. Teachers working on a non-sanction post who have already required NET select PhD degree will be entitled to get UGC scale of pay as admissible from date of
Mr.
approval of
Roy, just come to page 35, opening line. The director.
Yes.
The director of higher education Assam must ensure that that the teacher acquired the required qualification within the time limit fixed in OM dated 17/7/2004. And 17/7/2004 time limit is 2 years.
Lordship, here the I may be allowed to place again, Lordship, page 34, clause 4. Teachers working on a non-sanction post who will be adjusted against vacant sector post have not yet acquired full UGC norms will be required to qualify NET select within 2 years as per provision of the clause 40 as laid down in EOM dated 17/7/14. Otherwise, their services will be discontinued. Until then, they will be entitled to get basic pay as admissible from the date of approval by the director. So, Lordship, if suppose Lordship, I have not done NET or select Lordship, but I was entitled to get the basic pay Lordship. Not a single penny has been given.
You are
Lordship.
still working in the school.
Lordship.
You are still working in the school.
Yes, since last 20 years, Lordship, without getting any single penny.
Yes, Mr. Gugoi, what is the intent of this page 34, clause 4?
Page 34 is a continuation of the losses 17/7/2004 OM losses. It's a letter reference on the basis of that particular letter, it is clarified by the secretary.
What does it say? Clause 4?
Clause 4, teachers working on non-sanctioned post who have already acquired NET and SLET PhD degree will entitled to get losses who are appointed losses. Who are adjusted losses as per the 17/7/2004 OM losses. Those persons who are adjusted lordship and who have not attained the lordship which is required for MPhil NET and SLET lordship, then they have given 2 years.
Okay, you mean to say this only governs the persons who are covered by 17 to
77. Even lordship, that 2 years period was also subsequently extended by the honorable court in one single bench judgment into 5 years lordship. There's 2 years period in Aurobindo Kumar Sharma's case lordship. This will not cover the petition of state lordship.
Second submission, Mr. Roy.
Yes.
So October 2000, that notification is again in relation to 17/7/2004. You are held to be not covered by.
But Lordship, that is not practically Lordship, the lecturers or assistant professors Lordship, those who have not done the select or NET Lordship till date or PhD Lordship, they are getting the basic pay Lordship. I have conducted such 2 cases of this Mariani College's Lordship and Anju Pandey.
Where is the judge?
Of course, I have not come.
They are adjusted lordship. One is case Anju Sharma, my senior size appeared lordship. They are adjusted as
17/7.
77/2004 OM. They are not acquired NET and SLET, so they are getting a fixed UGC scale of.
They are getting the fixed pay scale.
of pay lordship.
And
So
there
because
are
of-
many hundreds
No,
of such
Mr.
teachers.
Roy, if they are the beneficiaries of 17/7/2004, they are entitled to that. But you are not a beneficiary. You are outside the purview of 17/7/2004.
Lordship, may
That
please-
is not my saying.
Lordship,
That is the finding of this court in the earlier round of litigation.
Lordship, may please to consider my name was sent for the regularization and my name was published in the regularization list, Lordship.
Where?
That your Lordship will find.
Yes, page 66.
Lordship may come to page 63.
Hmm.
Lordship, this is the regularization of teachers working against non-sanctioned post
Hmm.
to be regularized against the valid sanctioned post.
Hmm.
Lordship will find the name of the petitioner, serial number 13.
Hmm.
1367.
Hmm.
But till date, nothing has.
But Mr. Roy, I'll have to follow the earlier directions of this code.
Yes, yes.
Now come to page 71. This is a list of teachers working against non-sanctioned.
Even Lordship,
Now,
in that particular list also, the authority cannot act upon. As per the full bench and division bench,
That's
only 356.
300 or something is there,
356
17.7 for date cutoff date, about it.
Right.
Just come to para 7, page 71.
Yes, Lordship.
Uh, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines of second paragraph. Right hand side, though petitioner was appointed on. Though the petitioner was appointed on 23/11/2003, such appointment was against the sanction. So in spite of this document, the finding is contrary. And you have not challenged this finding. Therefore, the petitioner would not be entitled to benefit of the said OM dated 17/7/2003. So in that view of the matter, although the language may be wanting in the impugned order, but the content is, you did not have the UGC norms.
Lordship, we pleased to consider that in the earlier judgment, Lordship, the Director of Higher Education was completely directed, Lordship, that he has petitioner has already done his MPhil.
Fine.
That should be considered.
They have considered.
But the impugned order, there is nothing mentioned regarding my MPhil. And Lordship, the pertinent question is here, Lordship, when the college was under deficit grant system, Lordship, appointing authority was the governing body, not the director of the.
But they can't appoint anybody violating the UGC norms.
UGC norms were also relaxed, Lordship, and for those who have done MPhil, Lordship, that was relaxed, but subsequently it was withdrawn.
No, your thing would be on the date of your appointment.
Yes.
That also covered by Lordship. The Assam College Employees Lordship, the Assam Aided College Employees Rules Lordship. 1860, where the method of recruitment is a state selection. It's a
Lordship,
grants in 8 colleges. Lordship.
there is a judgment of this honorable court, Lord.
Give me
There,
something.
Lordship, this court is subsequently also MPhil or select or net can be done, Lordship. That is, this is the judgment of the Junu Devi page, Lordship. It is permissible, Lordship. There is no bar that at the time of appointment one must have the because the other MO also states that 2 years time is given for completing the net or select.
Not covered.
I appeared in this. I know this case better.
No, if
It was rejected. It was dismissed.
dismissed, but the last petition was dismissed, Lordship, but that petitioner was given liberty to file an application before the higher authority, and the higher authority will consider and allow him to do the net or select.
That was with regard to Royal of Senior School and selection grade. He argued, I think, for me and Mr. Nath.
One of the pertinent.
We argued, I think so, for around 3-4 days. This case.
Lordship, a person has been serving since last 20
Understood.
years.
Understood. You give me
Lordship,
a way out.
It will be
I
beggar.
am with you, but
It is-
give me a way out.
It will be beggar, Lordship. And the Honorable Supreme Court held that even in that case, Lordship, if no salary is paid, that will be in violation of Article 23 of the Constitution of India. And the apex court, Lordship, held that amount should be paid. Even I am entitled to get lordship even the basic pay as per the on aim of the department. Okay. Yeah. Yes. Lordship, may please to tell is Article 23. Bonded labor is not permissible law. It is pure case of
Understand.
bonded.
Understand.
At the relevant point of time, UGC regulation 2000 was in.
Yeah, yeah.
So I have given the regulation to reflect.
That judgment is of Apex Court is Lordship
And it has
1982
never
AIR
relaxed by any
147.
This last portion, I have marked it 1.3.3 lecturer. Then it was called lecturer at the time.
That is on bonded level. I have flagged this. Relevant.
Sir, go ahead. You have arrived at some decision. There is literally no, practically, we cannot say that it is erroneous. But the
My
decision
lord,
of
in
the court,
Madhuli,
the
actually,
decision of the court has to be understood with what is there on record. This court specifically required you to consider his case as he has got MPhil degree. Maybe he is not eligible, but one line somewhere missing. That is the grievance.
See, that part is not posed the UGC required norms, Lordship.
Fine, why
That
didn't you
part is
write, why
covered.
didn't you write
Yes.
it down here?
Yes, because,
He would not have had any
yes,
grievance.
because MPhil is not a required qualification.
I know
Lordship.
that.
So,
What
Lordship,
prevented your director in writing this thesis to write that one line?
that part I can otherwise, Lordship, the
You did not. I understand, but a citizen has been given a particular direction by this court. Aren't you required to consider that?
that part is there. Otherwise, Lordship, it says that.
Otherwise, I'm not even saying
Yes,
it is wrong.
Yes, not a UGC required qualification, as because it is required qualification is like 55% of marks, Lordship, along with net and slate, Lordship. Even
He did not have it.
Even PhD also.
He did
It
not
is
have
not
it
there.
till 2010.
Lordship.
Hmm.
That is the issue, Lordship.
But see, when this court had directed
Lordship.
a particular manner,
Lordship.
can you go beyond that?
That part we cannot go beyond that, but otherwise, Lordship, it is the.
He does not have. I'm not saying
Order is
you
inclusive.
regularize it,
Order,
but take into account this part.
order is inclusive, Lordship. Order, it does not reflect that. order
That
here-
we will have to deem it.
Lordship, the order.
No. The director, when he is required to
Yes.
look into a matter in a
Yes.
particular circumstances,
Lordship.
the result may be the same.
Yes.
I'm not saying the result would be
Lordship,
something,
yes.
but at least that much he should do.
That part is there. Otherwise, Lordship, the director never says that he has not a net, not a slate, Lordship. Only says that he has not actually required qualification. So it's, Lordship, the four corners it will, Lordship, cover, Lordship. And it is not a case that only petitioner is the.
No.
Like,
I think he has not done it. You come to
Lordship.
1, 2, 3, 4, 5, 6. Sixth paragraph.
Lordship.
The stand taken by this office during the course of the hearing of the petition was that since the petitioner did not possess required UGC norms, his
Yes.
appointment was not.
Lordship.
So by taking into account that submission,
Yes.
this direction was first.
Lordship.
So this paragraph at page 71 has to be given a meaning by the director. It may be the same thing,
Lordship.
but can I accept this order to be in compliance of that?
Lordship, even I cannot say, otherwise also, Lordship, the MPhil never a qualification for the.
Oh, This court rightly or wrongly has said something. It has not bound you by this. It said only consider.
Even, Lordship, my Lord Justice, UBI has passed that particular order
I know that.
regarding that.
I have read it.
He had passed that, no, not, I am not mentioning this particular order regarding MPhil part Lordship. MPhil part, he has delivered the judgment Lordship. It is not a required part,
No.
Biswajit put on case law.
And now UGC has itself come out with a notification
Lordship.
that this will not be.
And that was also adopted in 1998 Lordship by the government of Assam Lordship. And it was notified in 2000, 1998, 2000.
Even if we go by the last date of your adoption, that disputed period, if we give up also, 2001 onwards, this is the.
Lordship, in even 1997 onwards, Ministry of
I
Humanitarian
leave
Development.
98 to 2001 because it is disputed.
Is it
Some
disputed?
disputed can.
Otherwise also 1997, there is a Lordship.
But
clarification
for
of the
this
min-
case,
Lordship.
even if it's hold from the undisputed period, that is 2001, is not having the UGC norms.
We're not having, even Lordship, otherwise also Lordship, the gestation period in 2009 Lordship, there is a the resolution was taken by the UGC regarding exemption for the MPhil who has completed the MPhil prior to 2019 Lordship. It was came before the Honorable Allahabad High Court. Allahabad High Court in the favor of the petitioner, then it came to Supreme Court in P. Susila's case Lordship. The Honorable Apex Court says that the UGC is bound by the notification issued by the central government Lordship. But central government 2010 itself says that Lordship, they cannot exempt the Nathan slate in lieu of MPhil Lordship. UGC was Lordship abandoned.
Yes.
UGC notification of 1998 Lordship recognized the MPhil Lordship. And
There is a dispute in the state. I know that. From 2001 onwards, all advertisements, UGC norms, it's net. Before that, I am with you. I'll not hear Mr. Gogoi. There is in that judgment also you will find, that judgment you have given me, referential. There is a dispute. What is exactly the norms adopted? But I don't think so. From 2001, there is any doubt.
the Lordship, I am only, if I am not entitled to get the pay scale or regularized Lordship, at least I am entitled to get the basic pay Lordship as per the OA of the government Lordship.
No,
As well
once
as-
your appointment is not
as well
approved,
as-
your appointment is not approved by the director. The college may pay you, but the government cannot be directed to pay you.
At that time, it was not provincial. It was province only in 2005. 2005. Apart from that, my representation was
It's unfortunate, but
not
Only
because of
Zakat is
expert
changed, Lordship.
direction.
Only Zakat is changed instead of government aided college, it is a provincialized college. Only Zakat is changed. Otherwise, everything is.
old wine in the new bottle.
Lordship.
Anything more, Mr. Roy? Anything more? Please
Uh,
do.
Simply Lordship, the director higher secondary may be.
I was deliberating with him. I was thinking whether to have the matter remanded back to the director for that paragraph. But that again would be an empty formality because the result would be the same.
But the question is how the director will violate the direction of the High Court law.
That's why I am also denying that judgment.
There is no whisper regarding my doing empty.
And regarding two judgment regarding also selection part Lordship. One is delivered by my Lord Justice H. Roy, Supreme Court, that part. It is judgment. Two judgment in respect of Lordship, key judgment 17/7/2004 Lordship. Another just time reference regarding right to the right of the candidate Lordship.
Even for 1982 Supreme Court judgment Lordship, at least I am entitled to get my minimum wage.
That minimum wage, you will have to file a civil suit against your school. college authorities. Moment they approve, they are bound.
Yes.
And why bombarding with so much? He is having a very.
No,
bad
Lordship,
day.
just time, Lordship. No, nothing.
Okay, we'll give it a thought.
Lordship.
We'll give it a thought.
Always.
Dispose of it.
My lord, the record of it.
Otherwise, Lordship, Somua will
Material instructor.
Somehow I'll not get,
Material instructor.
somehow I'll not get.
लिखा है. Mr. S.P. Chowdhury, right? Okay. Yes, he has already done it.
Matlab, may I take,
I'll give it a thought, Mr.
matlab, may I take that book? Or lordship request?
This is not. Now,
Item 27.
Lordship may kindly fix any other date for this matter.
why?
The counsel leading this case is out of station, Lordship.
Yes, who is appearing? You take your seat, take your seat. Yes, Mr.
My lord.
Now, this 2173 numbers of OBP teachers, when were they provincialized or regularized?
They were regularized.
Yes, council, when they were regularized 2173?
Date is not mentioned, my lord.
Can you just get me that information?
I'll help you.
Because what you have done here at page 63, improved order, you have regularized it with prospective effect. That is 11/4/2018.
2018.
But the direction of this court is page 62.
Yes, at par with the two ones.
So that is not done. Can you just telephonically get that? So we'll dispose of this.
I'll try.
Right. Wait for some time. Only that much you want. What more you want? Just have that instruction.
My lord.
Item 28.
Here, my lord, the other day I made a submission before the court that
Ah.
a relaxation.
Relaxation.
But I have got the entire list against whom the relaxation has been exercised. See, I don't find the respondent number 6 name, the private respondent name in this. This relaxation was undertaken, Malab, for the purpose of those teachers, Malab, who were provincialized in 2013. And they, at that point of time, they don't have the 10 years of graduate scale of pay. Therefore, a relaxation process was undertaken by the government against 114 numbers of candidates in several districts.
What is the name of your school here?
Uzan Tarapur High School.
Uzan Tarapur High School.
District of
Qatar.
Qatar.
Is the school involved here?
No.
Is the name of the school
No.
here?
No. It is not. No.
Now, tell me one thing. Both of them are also eligible to this. Why they not given this relaxation?
That
Any school coming under the purview of the 2011 Act, provincialized in 2013, employees therein would be entitled to this automatically. Why was it not given?
that is there was some litigation, maybe.
What litigation?
Earlier, phone numbers of candidates, they have filed a petition matter before this honorable court. Because there was no gap, 10 years was not there. But the rule says, my lord, the 10 years teaching experience as graduate teacher, not in the graduate scale of pay. On that issue, the scale case was filed. And thereafter, the government has taken a decision. While taking the decision, my lord, they have, as the case was pending, they have not included the names of the petitioners. Subsequently, they have forwarded the proposal in respect of the 4 petitioners of that case, my lord. And thereafter, the government has given the approval. The policy of the government thereafter.
You both were provincialized on the same day?
Same day, same order.
Who is senior amongst you?
I'm the senior.
The age.
By age, by date of joining, I'm senior.
And that was the reason for recommending his name. by the state selection. This is the approval, my lord, is the old schools, which was left in the Kasha district. But that, the approval does not say anything about the relaxation.
Yes, Alphonse Philippe. Yes, Alphonse.
Yes, Mr. Mia.
My lord. From the procedure of law, my lord, as per the submission made by my, my lord, friend, that the relaxation is required, my lord. During the course of the hearing, it has come into light, my lord. And now, my lord, if the relaxation is required, then there cannot be any excuse for us also. And it has to be, my lord, an uniform application, my lord. And that's why they can follow the law and they can proceed, my lord.
He has participated in the selection process, my lord. And most important, my lord, he has made the ACR, both of him and of mine, my lord.
We are not even going into that.
Yes, sir.
We will not even go into that. Where do I get your ages, date of births?
Service books is the,
Huh?
service book might be the.
No, no, here, is there any document, seniority list,
Uh,
addition list, something? Okay. 1169 is the petitioner
My lord.
and 31,367 Selimuddin Losky.
My lord.
So 2003 rules, even if we apply, that criteria comes in. He gets it. Get the selection part. Because both of you participated. Now you can't come back and say that I was also not attached. After having not failed, not qualified. And the government cannot do it on pick and choose basis. And there is a justification because there were some cases pending, that's why it was not done. Otherwise, all the schools teachers, 10 years not completed, were entitled to that relaxation. Both of you parties. Now issue before us is, whom can we deem to be senior? Now, if I go by the criteria, both of you joined in 2003. Rest of the services I'm not eager to bring in. But if that being so, same day, then the differentiating factor would be the date of birth. And date of birth, she is at least 2 years senior to you. After that, you get it. But by the time you will be over 57, you will also not be entitled.
My lord.
Yes, any other submissions?
No,
Mr.
my lord, actually, what has happened, my lord, I am today, it's not handicapped by virtue of the bidding part, my lord. What has happened, the council, Mr. Fazil Ahmed Laskar, my lord. He has some, my lord, very seriously ill, my lord. So he
That's
has-
why you are not here, you came in today.
Yes, yes, my lord, that's why, my lord. So
Okay,
then,
we'll give you an opportunity, don't worry.
on next Tuesday,
We will have it. Mr. P. Kaushik, the Standing Council Education Secondary Department has produced before this court a communication dated 6/5/2020 by which the government had granted relaxation with regard to the requirement of 10 years service as a graduate teacher for being considered for the post of headmaster. Also, he has also placed on record a communication dated 23/6/2020 by which the government had approved the selection of the respondent number
Six.
respondent number five for appointment as headmaster, Uzan Tarapur High School, Ilibari. That's all. So, Mr. A.R. Mian submits that the council, you are in the case, Mr. Mian,
Lord, my name is there, but he was conducting me.
that the arguing council, Mr.
F.A. Laskar.
F.A. Laskar is presently under medical treatment.
Lord,
And as such, medical treatment,
Lord, yes, Lord.
and as such, prays that the matter be taken up on may not be taken up today. So prayer accepted. List this matter again on 23/1/2024. An endeavor would be made to dispose of the matter on itself. I'm just keeping this on. the
Item 29.
Yes,
Last subdivision losses that could bring some instruction. I have bring that,
yes.
there is nothing.
Now, were they all otherwise provincialized?
Except this.
Malati Bepari. Then how can you? Okay, she has been shown as an additional teacher. Mr. Via, have you gone through these instructions?
No, my lord, I have not done so, my lord.
Where's your appointment order?
Yes, my lord. My appointment, my lord, may be pleased to find page 37, my lord.
$37.
My lord.
Additional teacher.
My lord.
So
It was a, my
6
lord,
posts were given, 6 people were provincialized.
Lord, it was an appointment of 96, my lord.
I got it.
My lord.
I got it. But there were 7 posts created in that school at that point of time.
My lord.
Now, 6 people went away.
Provincial.
No, they went with some other,
Oh, no, yes, sir.
started another school.
Yes, yes.
So this school was required
Some
to
teachers, my lord.
teachers they brought in.
My lord.
So they brought in these people, 6 people, and accordingly,
My lord.
the 6 people were provincialized.
My lord. Living me, my lord. 7 posts were created, my lord.
That's not very clear.
That's the difficulty, my lord. Yes, my lord.
Originally, how many posts were created for this school?
Six, my lord, one, my lord, Sakida, including one Sakida.
including one Chokidar. And where is the provincialization order? Mr. Puyan?
My lord, that we do not have the access, my lord. My friend, that's why my lordship wanted to know regarding the how and in what manner they were provincialized, my lord.
Headmaster is also provincialized
My lord,
as headmaster.
My lord.
So 6 posts, 5 teachers, 1 grade 4.
Sure, my lord, grateful. My lord, my instruction is that the headmaster, before provincialization, my lord, he superannuated, my lord. 2005, my lord. Ramzan Ali Mandal. Yeah.
Mr. Bora,
My lord.
can you get a hold of a copy of that provincialization order?
My lord.
Hmm?
Can it be on Monday, my lord?
Not Monday, we'll give you some more time.
My lord, it will have to come from Dhuburi, my lord.
No, you take your time. We will have it later.
Okay.
We'll have it on 30th.
My lord, my lord, my lord, I'll bring it.
And give me the
This side.
breakup of the vacancies.
My lord.
Because he is an additional teacher.
My lord.
If the others are teachers and they have been recognized and all are senior to her, date of appointment. So maybe she will not have. Then her case has to be considered under the 2017. No, that also is not permissible.
She is 58 in the year 2021. Now I am going to retire, my lord. Very shortly. Probably retired, my lord. 20 in the year 2021, she was LPA.
We will check up that. No problem. But if she is entitled to something, she'll get a benefit from 96. Mr. P.K. Bora has produced before the court written instructions with regard to the manner in which the teachers of the school in Christian were provincialized. But however, the order of provincialization of the teachers of the school in Christian is not made part of the instructions. Mr. P.K. Bora on the next day shall produce the order of provincialization issued on 23/2/1980 pertaining to the school, employees of the school in Christian, as well as the orders towards provincialization of the services of persons appointed in the school after 23/2/1980. During the period, the provincialization of the services of the employees of the school was kept in advance. Just get that principle. The instructions as produced by Mr. P.K. Bora is kept on records and marked as X.
Oh, bless my lord.
Item number 30.
On 30. 30. Yes.
My lord, this is also a
Same day.
case. My lord, no, my lord, this is a case wherein, my lord, we have
Mr.
challenge an order of promotion.
I got it. Promotion page 23 is under
Page
challenge.
23 is under challenge, my lord.
You
My
come
lord,
to page, I'll show you.
21 is the seniority list, my lord.
There were some allegations leveled against the private respondent, saying that he is involved in some.
My lord, those allegations are not so relevant, my lord, but only thing is that whether the seniority criteria had been followed or not. Because this is a promotional post basing on seniority. my lord. And if my lord may be pleased to peruse page 21. My lord, I am the senior, my lord. And their contention, my lord, is that B.Ed is required, but as per the requirement of the rule, B.Ed is not required, my lord, for the post of assistant headmaster.
Oh, this is that. Yes, who is appearing? Secondary? Yes. Mr. Muzumdar, an order dated 7/5/21 is under challenge. Page 23. You have a graduate B.Ed degree.
My lord, but that is from Singhania.
Singhania.
Singhania, that is, my lord, also
For assistant headmaster is a B.Ed required.
not required. So it's 2021. Rule 15 of the 2000.
Oh, that's it.
Page 30. Page 37. For the post of, you must, for the post of assistant headmaster, you must be a BA, BSc, BCom. From any recognized university, he must have at least 10 years of teaching experience. So and so.
So,
B.Ed is not one of the.
then he is otherwise senior.
It is not only on the basis of seniority. Relation satisfactory ML confidential report also.
What was the position under the 2003 rules? Same thing.
2003, my B.Ed was. It was. 76. Assistant headmaster, minimum qualification for the post of headmaster, assistant headmaster shall be graduate in arts, science and commerce with BT and B.Ed degree.
Then, Mr. Miya,
Malak.
this exercise was started in 4/9/2017.
Under the 2003 rules.
Under the 3 rules. So,
That advertisement, we have not annexed.
the annex advertisement is letter is at page 33 of the private respondent's affidavit.
Hmm? 18 rules came into force in 2019, 10th of October.
So this process started much before that.
2003.
And you have not made any counter statement here to this affidavit.
Malak. Look, the B.Ed degree of this private respondent, Milok.
That is from the Open University.
No, Krishnakanto Handiko State Open University, Milok, and this is a certificate has been on 3/10/2019. Milok.
Where is your pleading to that effect? That is.
No, my pleading, Milok, has not been there, but it is a matter of record. Milok.
No.
Milok,
We will not assail his appointment on the basis of oral certificates.
No, I am not, Milok. My respectful submission before my lord is that, Milok, they have relied on a certificate, Milok, provisional certificate of Krishna Kando. It is here on that. This is political science.
Annexure B. Yes, this is the one, B.Ed. Indira Gandhi National Open University mark sheet is there. Page 34.
My lord.
Master of Arts is from Krishna Gandha Hendig Open University.
10/3/2017.
Okay. Anything more, Mr. Bhuya?
My Milord, regarding my B.Ed degree is from Singhania University, Milord. And that to that effect, Milord, government has not said anything till date, Milord. That degree, there is no pleading to that effect, Milord. No,
It has already been held to be
uh-huh.
by the government that it is not
No, Milord, the
from a
government,
recognized.
as I have specifically.
It's an off-campus thing.
No, Milord. Exactly, Milord,
Off-campus
as
thing.
ever-
Off-campus thing, they cannot go beyond their jurisdiction. University.
Milord, that issue, Milord, that issue, the government has not come up with any specific order that we are not giving the benefit of B.Ed degree of Singhania University in the state of Assam. Till date, Milord, government has not.
No, if
denied.
you go to Singhania University
My-
and take that degree, that will be a different ballgame altogether.
No.
But
I-
if you join some teaching institute here,
My lord.
off campus,
My lord.
that cannot be successful. Is not recognized. Yes, Mr. Mazumdar, what do you say?
He has not been able to point out any fault why 7/5/2021 is wrong.
He says his Singhania degree off campus.
Singhania off-campus degrees, unless given by the NCT, unless given by the NCT, Malad, the off-campus B.Ed degree will not be
Accepted.
accepted.
Milord, that is the issue subject is before this honorable court. Milord. No, Milord, what I beg to submit, Milord, regarding the NCTE with a university, Milord, there is no nexus with the NCT with the university.
It has to be there
Because,
in
Milord,
the only in the
when the degree is conferred by the university itself, Milord, then the NCT recognition is not required. That is the law settled by the.
Mr.
My lord,
Yeah,
my lord.
you come to your pleadings on that.
No, Milord, that pleading, Milord, on to that effect, Milord, there is, because my degree, Milord, my degree is from the Singhania. Now, if my learned
There
friend
is
say,
not even a whisper here.
no, Milord, if the learned friend come up with a pleading, Milord, we could have rejoined, Milord, the.
Not it, but that should have been there.
No, no,
Your
Milord.
case is
My lord,
that because that B.Ed is there,
my lord.
that is why my case is not being considered. Simple as that.
No, that is the issue.
And
Milord.
then you say B.Ed is not required under the
We have
2018 rules.
rules, Milord. That was because.
But
the
this is the
appointment-
selection prior to that.
That is correct, Milord. That, for that, Milord, I cannot, Milord, review because it is a process initiated prior to amendment of the rule. I have
Yes.
to submit fairly before my lord. But regarding my B.Ed degree, Milord, that has not been denied on any pleadings by the state, Milord.
You withdraw this.
My lord,
You withdraw this. Come back with a better pleading.
Milord, can they file an affidavit, Milord, to that?
Will not regard.
denying
We are satisfied with the contingency. And you come to page 7. This is your writ petition, Mr. Bhuya.
Yes, Milord.
Come to page 7.
Yes, Milord. That, the date of interest.
Third line. But the respondent authorities did not allow the petitioner or other similar from participate in the selection process.
Yes,
For so and so as the B.Ed degree obtained from CMJ University has not been considered. So where is the Singhania thing? This is CMJ University.
not the CMJ. Oh, no, Milord, it is correct, Milord. I am from CMJ,
Okay.
Milord. My lord.
But Mr.
So many
They are, yeah, I know that.
CMJ and Singhania has club, Milord, that is confusing.
I know, too much
I-
briefs. That sometimes creates a confusion.
No, my lord, I am sorry for.
We are,
wrong
come on, yeah.
supposition.
That's nothing. You please don't have those words. I say something,
My lord,
it's just open. That's all.
my lord.
I may be seen as a person who has already taken a view. I don't.
My lord.
But when I find something, I should put it across.
No, no, Milord, that's correct.
And don't give that look. It gives very deceptive. Right. Heard Mr. Airmia, current counsel for the petitioner. Also heard Mr. R. Mujumdar, current standing counsel,
Husband can involve-
secondary division department, along with Mr. B. Kaushik. I heard Mr. R. Muzumdar and Mr. B. Kaushik, learned standing councils, secondary education department. None appears for the respondent number 5 on call. The petition by way of the present application has presented a challenge to an order dated 7/5/2021, by which the respondent number 5 was appointed on regular basis or was promoted on regular basis to the post of assistant headmaster in Jamardhat, spelling 23 Jonata High School, Hubli. So, the petitioner has in his petition projected that the set selection, that in the course of the set selection, his case was not considered on account of the fact that his B.Ed degree obtained from CMJ University, Meghalaya was not considered valid by the state respondent. It is also projected in the petition that in terms of the provisions of Rule 15 of the Assam Secondary Education, bracketed Provincial High School Service Rules 2018, a B.Ed degree is not a requisite eligibility criteria. Possession of a B.Ed degree is not a requisite eligibility criteria for promotion to the rank of assistant headmaster. Full stop. The petitioner submits it is the further case of the petitioner that he, being the senior most incumbent in the school and admittedly being senior to the respondent number 5, he should have been considered for promotion to the post of assistant headmaster of the school in question, and accordingly raised that the order dated 7/5/2021 requires interference. From the records of the petition, we see that the selection process for the leading to the issuance of the order dated 7/5/2021 was initiated on 4/9/2017. Also, and thereafter, the process was taken forward. Full stop. The process having been initiated on 4/9/2017, the set rules of 2018 would have no application thereon, inasmuch as it came into force from
2019, October 2019.
Dash. Full stop. The set selection process is governed
10th October. 10 October.
10 October 2019. The set selection process is governed by the provisions of the Assam Secondary Education Provincialized Service Rules, Assam Secondary Education bracketed Provincialized bracket over Service Rules 2003. Also, the provisions of Rule 14 of the said rules of 2003 mandates that for being eligible for selection as assistant headmaster of a high school, the person concerned must, in addition to having the requisite teaching experience, must also have the minimum qualification of graduate in arts, science or commerce with B.Ed, PT or B.Ed. The petitioner admittedly not having a valid B.Ed degree during the period. His case for promotion to the rank to the post of assistant master was under consideration from us. The respondents have rightly rejected the case of the petitioner. And only by virtue of his seniority, petitioner cannot claim for promotion to the rank of to the post of assistant master, ignoring the statutorily prescribed qualifications under the rules of 2003. The respondent number 5, having the requisite eligibility criteria as mandated under the provisions of Rule 14 of the said rules of 2003, was on consideration selected and appointed as assistant master of the said school in terms of the said school by the order dated 7/5. In view of the fact that the petitioner did not possess the requisite eligibility criteria for being considered for the post of assistant master, the contentions raised by the petitioner does not merit acceptance. Accordingly, those petition stands dismissed. However, there shall be no order as to cost. Yes.
Applies, my lord.
Item number 32 and 33.
Finally, here is the order dated 6/12/2023.
Yes. Yes, Mr.
Lordship, I've got some instruction, Lordship. I would like to place it here.
Please,
Lordship,
you can give me that copy.
no.
You have got it. It's okay, she's got it.
Oh, 27/1 from the last paragraph, 2008.
Give him a copy.
Well,
You take a copy. We'll have it. Mr. A. Fukan, in terms of the earlier directions passed by this court, has produced a written instruction from the Director of Elementary Education. Assam. A copy of the same is required to be furnished to Mr. M. Khan, Learning Council for the petition. List this matter again on 2/2/2024 for further hearing, for further consideration.
Item 34.
May I please, your lordship? This matter, my lord, pertaining to further one appointment as assistant professor in the applied zoology at the Indian University. And respondent number 6 has been appointed in contravention of the adverse.
But I find that the respondent number 6 service is yet doubtful. There is no clear cut.
But so far, my lord, office note, office note dated 13/12, my lord. The service already confirmed.
But there is an order.
And
28/11.
lordship,
Regarding service on respondent number 6, the question remains open as to actually it was served or not, as the note of the Laujima court is only upon a track consignment report, which has no evidentiary value under the law.
But prior to that, my lord, my lord,
What the honorable court on that day had felt was that a postal certificate that it has been actually delivered is maybe a piece of evidence if a certificate is there, but
I know
this
that.
kind of a printout from the email would not suffice. In any case, my lord, I was.
and
I'm
so
the
far, my
Blue
lord,
University
order
and
dated
praying-
22nd.
Mr. Bhiya. Why don't you take, where do you stay? Where does this petitioner stay? House of the petitioner?
And lordship, Mr. R. Deka enter appearance on behalf of respondent 6 on.
Okay, somebody has entered appearance.
But I could not find any Vakalatnama on record. I don't know.
Wait.
22nd,
There is an order saying R. Deka is-
second 8, my lord, order, my lord.
But the
One-
same
one-
order
one-
says that this is not complete.
One counsel, Mr. R. Deka enter appearance on behalf of respondent 6.
Order dated?
22nd of August, my lord.
Okay.
Lordship, is there further down the order?
R Deca,
Further,
R Deca.
a little bit down also.
Where
Again, the
is-
sixth
yeah,
part comes.
complete.
It is incomplete again.
No, no,
Although someone is shown as
22/8/2023 আসেনি ওকালতনামা ঠিক মনে
Mr. R Deca appeared. And my learned friend appearing on behalf of the university. University, correct.
No, one second. We will resolve. This is item number 34.
34.
No wakalatnama. The petitioner to take fresh steps on the respondent number 6. Prove by thusly prove the register Dibrugarh University, Dibrugarh. Full stop. The rest, thus the service shall be routed through the registry of this school. Full stop. The petitioner shall hand over the notice to the register Dibrugarh University, who shall then have it served upon the respondent number 6 in the presence of 2 witnesses. The petitioner shall thereafter file an affidavit with regard to the service of the notice. Mr. R. Majumdar, you have already received instruction on the last date.
My lord, I had sent the affidavit also. It was not come
Mr.
back.
R. Majumdar pays for 2 weeks' time to file its counter affidavit in the matter. Accordingly, list this matter again on 19/2/2024 with a report of 19/2/2024. So, pleadings be completed before they said date.
Timing item 27.
Yes. Huh?
Take this matter next week, my lord. I
Okay,
tried to get
okay.
the
On the prayer of 27, on the prayer of Mr. B. Kaushik, list this matter again on 25/1/2024.
35.
Yes,
My lord, that is the case, my lord, we have filed affidavit.
I know that, but
Yeah.
today I'm sorry, I missed this, I means just lost it. Others, we could have upgraded this along with the other matters.
All lordship can it fixed on any Tuesday, Thursday,
That's what I'm saying.
lordship's convenient, my lord. Otherwise, case is ready for final discussion.
It's that with regard to that subject competition.
Subject.
We have heard this matter substantially.
That's it, my lord.
On the prayer of the parties, list this matter again on 1/2/2024.
Is this?
1st of February.
Also.
Any problem?
My lord, interim to be continued.
The interim order passed earlier shall be.
Item 36.
Why are you not filing your affidavit here?
We have sent it for vetting, my lord.
On the prayer of Mr. P.K. Bora, list this matter again after 2 weeks. On a date to be fixed by the registry. Also, in the meantime, the state respondent shall bring their stand on record by way of filing.
My lord, no problem.
Item 37.
Miller. In this case, Miller, on behalf of resolution number 5, I have filed an affidavit today, Miller. So, Miller,
Okay, fine. Your affidavit we will consider.
yes.
Now tell me one thing. When did you retire from that school? Which one? Item number
37.
2020.
37?
37.
You are in 37.
Yes, Miller.
You are for the respondent number?
5, Miller.
Okay. This is with appointment of,
President of the Miller government.
you were a teacher in that school, college?
Yes, I was, Miller.
Then how can you be considered?
Because, Miller, there is a provision, Miller.
Where?
Yes, Miller, 27, Miller.
Page?
27.
27, okay.
However, my lord, for any valid,
Where is that relaxation? Show me.
that will be my lord, the,
You will have to show. You have not even pleaded that. Okay, your affidavit is coming.
yes.
Give me a copy of your affidavit. You might have brought on record the fact there that there was relaxation. Please show me. It's only on that, Mr. Kimes.
And my lord, secondly, my lord, what is their locus meaning? Because my lord,
Forget their locus. They have brought it to our notice. We will now proceed. We are not even questioning them. We are not even hearing them. But I want to know how you came to be appointed. Why this great rush in appointment of managing committee president, secretary nowadays?
it will be my lord, considered my director of my lord, higher education, my lord, on what basis they have been considered. The record will say.
Yes, Mr. Das. How come he is appointed? I don't want the records. I only want an instruction. How Mr. Qayyum has been appointed, whether there is a relaxation made on the basis of a proposal of the director, produce that proposal. We will allow this, we will dismiss this. Yes, Mr. Qayyum. List this matter again on 2/2/2024. On which days Mr. Das shall bring on record materials to justify the appointment of the private respondent number 5 as president of the college in question. What's up? Also, it is alleged in the petition that the appointment of the respondent number 5 is in clear violation of the office memorandum dated 5/11/2014 governing the procedure for appointment of presidents of governing bodies of colleges in the state. So, you get that instruction. And Mr. Qayyum, you should also place that because I find there is nothing in your.
Yes, because my name was proposed by the local public, then it was forwarded to the.
No,
I have nothing to say.
Respondent number 3 formal category stated, madam.
Yes.
Item 39 and 40.
39 to external usage.
To cut short my argument, Lordship, may I take your Lordship to page 35?
No, they have given a justification. We'll hear this.
But this is regarding my verbal dismissal from service.
I know that. Both will have a time. We will hear this.
But Lordship, if your Lordship comes to page 35, till 2039-2023, post of Assistant Finance and Accounts Officer was there.
But
And
today,
I-
when the government has taken sanction post, that post is not.
It is their contention, Lord.
No, they are saying you show that the post still continues to exist in the roles of the university.
And Lordship, if your Lordship comes to page 41, all others were given extension, Lordship.
I got
Barring me,
that.
barring me, Lordship.
But for you to be granted an extension by this court, you must show that the post is there. On the prayer of the parties, list this matter again on 1/2/2024. On the date, on that said date, endeavor would be made to dispose of the reputation.
Sure, instead of 1 second, madam.
Second, then it will go to 5/2. Any problem? 6/2. Okay.
So for item number 40 is concerned, we have the information that the Honorable Vice Chancellor has directed not to fill up any post for 6 months, Lordship.
Okay, fine, very good. Good for you. Yeah.
Of the-
39,
Item 42.
39, 40. Yes,
My lord, here petitioner was appointed as assistant.
yes. What is your stand
My lord, we have not received instruction. My lord, here petitioner.
on the
has filed an
prayer of
appeal.
Mr. P.K. Bora? First day, we'll give him.
No, my lord, notice has been issued.
I know that after notice was there. Nothing urgent here. On the prayer of Mr. P.K. Bora, Standing Council, Elementary Education Department, lists this matters again on 9/2/2024, facilitating him to place on record the stand of the respondents.
Obliged, I am obliged.
Orders, item 43.
Please, Lordship. My lord, here, my lord, we have taken steps, my lord, Lordship, kindly have a look, the affidavit dated 8/11/23, my lord. They have duly acknowledged and received, my lord, but did not feel necessary to endorse lawyer or to come, my lord. Page 28, my lord, he has duly been acknowledged,
Oh, you have taken Dusty.
my lord.
Okay, not Dust. Okay, fine. Yes, Mr. Fukan.
My lord, it's regarding approval to
It's the university, my lord, the ball is in the court of the education department, my lord. And he has to.
Oh,
appear-
that case.
That-
Where is your instructions we sought?
on that Hare Krishna Sharma case, my lord.
Or not this?
Not.
Same. Hare Krishna and the same.
That
Subject
was
matter is the
repetition.
same, my lord, what I understand, my lord. I was there in the court.
Because I had dealt with that. When have we fixed that matter?
My lord, this last week of this month.
Number two, what is it? Number two. I
You
may have
just
the
give that,
number, my
Mr.
lord.
Bhuya, you just give that number to me.
Yes, my lord,
Take
I
that
may
number.
have it just now, my lord.
That is also a contempt matter.
No, my lord, read petition.
That's a writ petition.
My lord. The verification process is underway, my lord, as per direction of the.
Same order in this.
This is, my lord, what happened, writ petition was allowed. Then, my lord, department came for review, my lord.
That was
Review upheld the order of Honorable Singhal.
so on the prayer of Mr. P.J. Fukan. List this matters again on 6/2/2024, on which date Mr. Fukan shall place on record the updated instruction with regard to compliance of the directions, violation of which is alleged in the present proceedings.
Most of them.
Number two, absolutely.
Item 44.
Content. I have received updated instruction yesterday. Maybe even two or 3 days time. Next week I can file my affidavit on these instructions.
Now, what is more left?
My lord, that the process has been done, we have sent the proposal and agreed to finance. I just want to bring it on record. That is the instruction that everything has been processed from our end. It has gone. That is what I'll bring
On
on
the
the.
prayer of Mr. R. Mujumdar. Learned Council for the respondents. List this matter again on 6/2/2024, on which date he shall place on record a status report with regard to the compliance of the directives, violation of which is alleged in the present. I don't want the affidavit. Give me a compliance report. That will do. Status.
Everything has been. Status report I have today also I can give.
Finance is a party here. If not include, give a copy include.
Item 45.
Maybe
Yes.
I'm praying for adjournment, Lordship. The
Why?
youngest, Lordship, the youngest counsel went to his native village, Lordship. He could not come due to some medical issue, Lordship. On that
List
ground,
this
I'm
matter
praying-
again on 29/1/2024.
Highly obliged.
Item 46.
Await service report on respondent number, full stop. Await service report on respondent number 50. List this matter again on 7/2/2024 with an updated report as regards service of notice on the respondent.
And on that day, my lord, the respondent would file the, as per earlier order.
It's already there.
Supplementary list item 49 and 50 for orders.
This will have to be fixed on 24.
Item
24. It's already fixed on 24.
already.
WPC number 7365-2023. List this matter again on 24/1/2024 along with WPC number 3100
It's already there in item 50.
22. No, 24th is there in the other case.
Yes.
This also have.
Yes.
Daily list for hearing item 47.
Okay. Yes, Mr. Pukan.
Lord, it's a very simple case, my lord. He's a Gaon Panchayat secretary, my lord, under Tezpur Mahkuma Police. Since 1994, he has been serving, my lord. After
Yes,
12
Mr. Doctor.
My
What is
lord.
your stand here?
My lord, fairly submitting affidavits are not up to.
No affidavit. This is not even an affidavit.
Yes, yes.
Nothing is there.
Very poor, my lord.
What is your stand? We have not been able to make out a head and tail of your stand from the affidavit.
My lord. On law points, my lord, they have to
Only
satisfy, my lord,
understand, my lord,
because
that the petitioner
some-
papers have not been, my lord, forwarded for.
At that point in time.
after some, my
Nothing
lord.
Now you tell me one thing. Here there is a stand in the order, impugned order 711, that the provincialization or regularization of the other secretaries were cancelled. I don't think so. That is
No,
fact.
no, that is also not correct. My lord, in fact, there are some reference of two read appeals, my lord. These are also for proposal.
nothing to do with
Nothing
this.
to do with this, my lord.
Not really then.
But my lord, on law point, my lord, after Uma Devi, whether they are eligible or they are taking the benefits of the fixed pay, my lord, that have to look into.
It is prior to
This
Umadi.
is
Because
after
they
Uma
cannot
Devi,
choose
all
the
the
both, my lord.
exercises.
Petitioner cannot choose the both, my lord, whether they have to, my lord, choose only one, my lord.
You have that instructions,
Yes, I'll.
but this is a 13th matter. I'll not
Yes,
give you
yes,
much
yes,
time.
no, my lord, yes,
We will have it on 29th.
29, yes.
List again on 29/1/2024.
No,
On
can
which
it be
date,
on,
Mr. Doctor?
On 1st of February, my lord.
1st of February, on 1/2/2024. On which date, Mr. Datta, Learned Standing Council, PNRD Department shall place the stand of the respondents in the matter.
My lord.
In the event, no instructions are furnished to Mr. Datta, the matter shall be proceeded with basing on the materials available on record.
My lord.
Most of them.
Highly obliged.
Item 48.
Yes, Mr. Burman,
Yes, may please your lordship. Repetition relating to.
you tell me one thing. What is the rule on the date of your consideration?
Rule, rule 11 3C.
PC as amended.
As amended, lordship, the amended rule is not applicable for me.
Why?
Even I was eligible before amendment.
Forget it. There is an
Other,
order of this court. This order 6/12/2019 does not require a retrospective consideration in your case. Yes, Mr. Gogoi.
Consideration on 2020 lawsuit. Lawsuit.
On that day, what was the rule holding the field?
Lawsuit
81
rules lawsuit and the
amended
required,
then?
required qualification is page 94.
I know, I got it.
Okay.
But he says, naturally, his argument is that it's not applicable because he was appointed prior to that.
Lawsuit. That part is not lawsuit. It's a covered by the lawsuit that doesn't
Rajkumar's case.
Rajkumar's case covered by lawsuit.
We will hear this.
And also lordship, I was applicable before amendment. I
Fine.
applied.
Mr. Burman, you approach this court.
Yes.
There is a direction prospectively to consider. That direction now I can't make it retrospective. Can I?
Even the amendment is not applicable for me.
To you because why?
Because such amendment is only for direct recruitment, not for promotion.
That was what I was yesterday night. I forgot the issue. I dealt with such matters long back. That's what I was trying to figure out yesterday. The thing is that prescription for direct recruitment is incorporated for promotion. Unfortunately, you go through the rules. You go through the rules once and read their affidavit. List on the prayer of the parties, list this matter again on 8/2/2024. 8/2/2024. What was it?
List of.
Your Lordship, for item number 25, another date is required. 15th February,
What was that?
7/2/23, 24, sorry. Item number 25.
Mr. Ahmad is not.
Jai Ahmad, Jai Ahmad.
Oh. What do you want?
New date, 15th February.
15. Okay.
And your blessing.
15.
মুকুটক করে দিছি।